What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta. I am a small-town lawyer in central Minnesota, and today we are live, as we tend to be lately, and we are live because LANDAU, LANDUI, pick your moniker for this beautiful man. And I mean it. He is a handsome fella. He really is. For this beautiful man, he has responded to Patreon and Jordan Cope's motion to dismiss in the ongoing LoLsuit between George Zunian, Jessica Irene Blum, and Dax Herrera et al. Et al. My first concern of the night, though, is a short prayer for Asterios Kokonos. The Rafter immediately says Jesus Christ is keto. I agree, he is. No carbs in that man at all. But let's have a moment of silence for Asterios, who I heard potentially killed himself with liquor. And as funny as Asterios is, we don't want him dead. And we certainly don't want him drinking himself to death. So, Lord, please watch over Asterios Kokonos, our good friend, and make sure that he makes it through the night. So hopefully he can watch this tomorrow. Amen. Asterios died as he lived, full of liquor. All right, tonight, guys, is a special night. All of these live streams are special nights to me. This is White and Mackay. I still have some of this left because I am only drinking it really on live stream nights, and that is fantastic. I need just a moment, though, so just give me one moment. I'll be right back. Or you follow the instructions. Sorry about that. I just had to help out Lady Rekieta. And, of course, she is a wonderful person who is the most important thing in the world to me other than the kids. They all kind of tie. But now that we're back, let's see what we have here. We have a notice of motion. And a cross motion from Kevin Landau, which we will go through. It's very short. And then we have, of course, his beautiful 31-page memorandum of law. White and Mackay sounds pretty racist. I agree. They should fix that in Scotland. The memorandum of law, which is a significant document, 31 pages. We'll go through it as quickly as possible. And then we have one case that Landau seems to have conveniently omitted, which I will go through. It is only a page long, and we'll see what happens. Windows 95 says, this is my spite budget for the month. I gave Asterios Kokonos £5, but he was too drunk to see my super chat. This is public shaming of him. Shame. Shame, Asterios. Shame. Shame. I agree, he should be shamed. Yes, I can talk about the temporary restraining order drop to the knowledge that I have. And that is, there are numerous reasons. So before we get started, if you're just tuning in for the first time, Kellen Miller says, Landui aside, will I ever do a stream on the DUI exception of the Constitution? There are lots of problems with DUI process, and yeah, I'll probably do a video on them at some point. But let's talk real quick about the temporary restraining order dropped. So the last video I did was covering, or last live stream I did, was covering the temporary restraining order, and that was very interesting as Kevin Landau decided to try and restrain the entire internet from speaking about him, Maddox, or Jessica Irene Blum. And then he, 2 days later, I believe it was, withdrew that temporary restraining order, or the motion for the temporary restraining order. We don't know why that happened, but there are a couple reasons for it. One, he either decided it was too dumb to go through with it because it was an unenforceable motion, and it just could not be done by the court. The court does not have jurisdiction over me, for example, so he can't stop me from saying, hey, Landau, you got several DUIs. You shouldn't have done that. That was a terrible decision. And he can't stop me from saying, Maddox, you're an unfunny cuck. He can't do that. So he could have gotten rid of that for that reason. Another reason is there is the possibility, of course, that he and Dick's attorneys struck some sort of agreement that would no longer necessitate the order. That's a possibility. Unfortunately, we cannot know if that's what happened or not because we aren't there and we are not their attorneys. And just so for any dummies out there for whom it is unclear in watching these videos, I do not represent you or anyone else in these in the matter at hand. I have my own practice in Minnesota, not a practice in New York or California. I'm not representing Dick or anyone on his team, and I'm certainly not representing Maddox. So, you know, there's that. If anyone is still, if it's not clear, right? Just if it's not clear for anyone out there, I am not representing anybody. I'm just offering commentary. Move the camera down like 2 inches. Okay. Is that better? Hopefully that's better. It's a little weird. All right. Let's see. What do we have here? Oh, yes. Back to this document at hand. Let's just get on with it. First. Wait a minute. That's good. Couple more pieces of housekeeping. I got a gift today in the mail from Paul Evans, who I am a huge fan of, for sending me this gift. Right there. Look at that. This is a fantastic book. I strongly recommend it. I've paged through it a couple times. It's great. Thanks a bunch, Paul. I really appreciate it. Lots of laughs for me and the missus so far with that one. The next piece of housekeeping is, of course, patreon.com/lawsplaining. That's where you can find all of my content as it gets uploaded. There is bonus content for $5 patrons and $10 patrons and $20 patrons. And if you want to give more than that, you're welcome to. As for the chat, as always, there are 2 ways to contact me as I do this stream. I do not monitor the chat super close because it's very distracting because you guys are hilarious. But if you tag me, like Kenster1790 just did with 2 questions, can Landau refile? Landau withdrew the motion without prejudice. Can we deem the withdrawal without prejudice? The answer to those questions are backwards. He requested to withdraw the motion without prejudice. A judge doesn't have to do that, but he probably will. And then if it is withdrawn without prejudice, then yes, he can refile. The other way to get a hold of me is, of course, through the super chat feature. I never say anyone has to donate money to me to get a question answered, but I do appreciate the donations, and it puts the questions right in front of me. Or if you just need me to say something or give a shout out to someone, that's an option that you can certainly utilize. Yeah, so those are the 2 options, tag me or super chat. Otherwise, I'm going to go through this. I have been getting some feedback that maybe a little bit too much of the interaction with the chat, and I think that is suppression of your guys' rights, and so I will interact with you on as much as possible. And this stream is dedicated to Jesus Christ, according to Matthew Reifler, which I agree. And Maxwell Silver says, patreon.com/Asterios. He now needs hospital bills as well as legal bills, so help him out. On to the motion. Let's get this stream moving. So please take notice that upon the annexed affidavit of George Azunian, professionally known as Maddox, and professionally is a stretch there, Sworn to on the 22nd day of February 2018, the affirmation of Kevin Landau and all exhibits annexed thereto. Guys, I went through the exhibits. They're not really interesting. We'll cover what's in the exhibits when they reference them, if it matters at all. But I'm not going to bring them up on the screen. It's just a waste of time for this one. For my devil, you bunch your toilet paper. Don't fold. That's me. The accompanying memorandum of law and all pleadings and prior proceedings herein, plaintiff will move at the New York County Supreme Court before the Honorable Charles E. Ramos at the motion submissions part, room 130, 60 Center Street on the 9th day of February, March at 9:30 p.m. If you don't know, there is now another month that happens between February and March. It is February, March at 9:30 p.m. or as soon thereafter as counsel may be heard for an order pursuant to CPLR 3211D to deny defendant's motion to dismiss without prejudice and allow plaintiffs to conduct discovery on personal jurisdiction. Please take further notice that pursuant to these two rules, CPLR 2214B and 2103B, reply papers, if any, are to be served so as to be received by the undersigned at least 1 day prior to the return date on this cross motion. Respectfully submitted, the Landau Group, PC. So the motion, they're replying to the motion to dismiss, asking for it to be denied. And then they're asking for it to be denied without prejudice. And this is kind of a way for them to slightly justify or attempt to justify their cross motion to allow discovery on personal jurisdiction on Patreon. If they're going to do a cross motion to allow discovery on Patreon, they would dismiss the motion to dismiss without prejudice and allow Patreon to refile after discovery. This is nonsense. This is a delay tactic designed to cost people money and drag this litigation out longer. Nothing else. Jason Benaim says your mic is muted. So, I don't think so. But thanks for the heads up. If you can't hear me, I apologize. Watch me drink. Fresh Prince Noctis. I have so many babies. And I'm a one lady kind of dude. I don't know if you're a lady. All right. On to the memorandum of law. So he has fixed. By the way, does anybody know, are we live in Portland? Because that would be really hilarious. Really hilarious. Phoenix 7289 says, hee hee, February, March, Alex. I'm hoping we are live at the pre-party for Road Rage. If you are there and happen to be seeing this, I'm sorry I can't make it out there, guys. I hope you have tons of fun. Hope to see you at some future live show and have a good time tomorrow, because it was a ton of fun in Chicago, and I'm sure you'll have a ton of fun. Enjoy the night. If you're able to watch this, that's great. If not, watch it later. All right. So here we have plaintiff's cross motion to dismiss and for discovery on personal jurisdiction pursuant to CPLR. So, guys, people make mistakes. Right? People do make mistakes. And it's not funny to make fun of mistakes unless they're just catastrophic. But sometimes they consistently make mistakes that they shouldn't make anymore. And at that point, it is right to ridicule. And this is not a cross motion to dismiss from the plaintiffs. Like, this is a response to a motion to dismiss. Plaintiffs are not requesting dismissal here. So to say plaintiff's cross motion to dismiss would be to imply, or not even imply, but state directly that Maddox is trying to dismiss the case. I think the judge should grant it. That would be great. That would be great. And for discovery on personal jurisdiction. That is the cross motion. That is the cross motion pursuant to CPLR 3211D and Memorandum of Law in opposition to defendants' Patreon and Cope pursuant to CPLR 3211A7 and 8. Gigawarp says, Asterios drinks his whiskey with Diet Coke. You need to educate him. Yeah, Asterios. Neat. Whiskey, neat. Come on, man. All right. So, he has still not fixed the apostrophe up here. in the caption, but he did finally fix Jessica Bloom from Jane Doe to Jessica Bloom. So there's that. He still hasn't fixed the apostrophe down here. Guys, he's not good at apostrophes. I don't know. Should I chug this whole bottle of wild turkey? Maxwell, are you legally able to drink a bottle of wild turkey? I cannot advise you to break the law. Alan Foster, my flight to Portland leaves in 6 hours. Oh, and Landau is a cuck. Have a drink, Nick. Okay, thanks. All right, buddy. And Windows 95 says, if you send a super chat, please hashtag shame Mysterios. I agree. I agree. Shame that man. Hope he lives, but shame him. All right. Here we go. Plaintiffs George Azunian. Plaintiffs apostrophe. Hereinafter Azunian. And Jessica Blum. Collectively, plaintiffs. Ashley Princess, I like my whiskey on the rocks. Rye whiskey. Ashley, I will say that some whiskey is great on the rocks. Really. I always drink the first glass neat, but some, including Wild Turkey, is very good on the rocks. Through their attorneys, the Landau Group PC respectfully submit this cross motion pursuant to CPLR 3211D and their opposition to defendants Patreon Incorporated and Jordan Cope, collectively defendants motion to dismiss pursuant to CPLR 3211A7 and 8. Statement of applicable facts. Here we go. Let's see. So this is interesting because, again, remember that they're not allowed to add information to these motions. You have to do all of the information in the pleadings. There is a limited exception for contested jurisdiction where you can add some more information to show that jurisdiction is warranted. However, I think you need to make a prima facie showing, and prima facie is Latin for on its face. Prima facie showing of personal jurisdiction prior to trying to overcome contested jurisdiction, which I don't think they ever made a prima facie case for jurisdiction, certainly not on Patreon, who does business in California and I believe is incorporated in California. If not, it's incorporated in Delaware. So Patreon is an online platform that allows individuals to set up a web page for their creations. The creator of the page can then charge each patron a fee or pledge to access said creations, e.g. a monthly fee of $5 for access to the creator's podcast. And it is important to know that if you want an example of this, please go to patreon.com/lawsplaining. In addition to this fee, creators can charge additional fees or pledges whereby their patrons may pay additional fees. That's a bit redundant. To access other content. That's not actually true, right? Patreon allows you to set up tiers, but it's not an additional fee. Like, I don't get to just add charges. I don't think. If I can, let me know. I'm a capitalist. Such as an extra podcast or merchandise. Likewise, creators can create incentives or pledges for their patrons, whereby if a patron does X, No, they can't. No, they can't. The creator may give gift such patron a t-shirt, merchandise, or other bonus content, or access to creators such as a meet and greet. Patreon's fee is typically 5% of the process pledges. Therefore, whoever has the most patrons will typically make the most money. No. Nope. Whoever has the most patrons and the highest per patron average will tend to make the most money. It's not just about the most patrons or the least patrons. There are people with very few patrons who make quite a bit because of the type of work that they do. And then there are people who have lots of patrons, but, they don't tend to make a lot of money because their per patron contribution is very low. So these are weird sort of statements to make that are unnecessary. None necessary. Notifications to Patreon by Plaintiff Azunian. So here we go. Here we're going to try and determine that all of the things that George said to Patreon should be taken as fact and introduced into this document. This is, again, a weaselly way to try and prejudice. Guys, you have a couple ways to fight a lawsuit, right? And one of them is to attempt to poison the well against your opponent. Like by maybe filing a frivolous motion for a temporary restraining order. That might be a frivolous motion in an attempt to poison the well. Or by trying to introduce all of the evil things that someone's fans do and then attribute it to them, like they're about to do now. Or by repeating all of the notifications to Patreon that Plaintiff Azunian made before he was under oath. They're under oath in these motions, but he wasn't under oath when he made these statements to Patreon. These statements could be abject lies, and he could truthfully say he reported them. So this is a fun attempt to poison the well and prejudice the judge against Dick Masterson. That's all this stuff is, and it's so transparent. It's badly done. Badly done. All right. Okay. On or about January 16th, 2017, Patreon was notified by Plaintiff Orangutan of Defendant Herrera's harassment campaigns against him and Plaintiff Blum with information and documents, including Herrera's fans creating a rape list, which, did they, Maddox? Was it Herrera's fans or was it your fans? Doxing by his fans. Notice you have doxing in quotes. You don't define it, and you don't say what the actual doxing was, because I'm gonna guess it wasn't actually doxing, because no one has released your personal information. And by the way, many of us have it because you're a relatively public figure, but we don't actually release it because doxing isn't cool. And targeted Twitter harassment, whatever that is. On January 18th, 2017, a follow-up email to Patreon was sent whereby Plaintiff again informed Patreon and Defendant Herrera's harassment and threats. Quote, Herrera has attacked my girlfriend, private individuals I'm associated with, small businesses and companies I've worked with, disclosed my private finances on the air. When he talked about you wasting $30,000 on a web page, on a web page that like you could make with a WordPress plugin? Really? And even made fun of and disclosed mental health issues my family is dealing with. Which ones? Like the fact that you're a horrific narcissist or you have histrionic personality disorder? Are those the health issues that your family's dealing with? Are they your health issues? I've been doing this for 20 years and I've never seen anything like this. Oh, guys, I forgot. What I was gonna do was pull up Maddox's webpage and do this on your own sometime, I guess. If you go on Maddox's webpage, you can find where within his 20 years of doing this, he actually literally created a harassment campaign against some poor schmuck customer service rep who ended up losing their job, right? So in your 20 years, you've never seen anything like this? Were you not watching when you did it? That's the real question. Please let me know if there's any other information I can provide. Thanks. On January 26, 2017, Plaintiff Orangutan provided Patreon with another follow-up and with another instance of harassment and stalking on Facebook by Defendant Herrera directly. Notice that this one was directly, the others were indirect because they didn't actually happen. And neither did this one. It doesn't meet their... Maddox, buddy, it doesn't meet their definition of harassment and stalking in their terms of service that you agreed to. On May 26, 2017, Plaintiff Orangutan made another complaint about the escalation of harassment, which included the release of Plaintiff Jane Doe's full private name, Jessica Irene Blum. Rape threats by Herrera's fans, that's the fans. Doxing by his fans, it's not Dick, man. And Herrera's threat to put up a billboard by Plaintiff's house, but he didn't do it. Trey Y says, Lettuce Jones! I agree. What's up, Lettuce Jones? On June 29th, 2017, Plaintiff Orangutan sent Patreon another email, Thirsty Much Maddox, to make them aware of the racist death threats that Plaintiff Jane Doe received, and of Defendant Herrera's threat to release Plaintiff's private letters to his ex-girlfriend. Notice the racist death threats, as we have shown, as Reddit has found out, all belong to Mr. Burgers, as he admitted they were from Mr. Burgers. Not from Herrera. Not from Herrera. Barely from one of Herrera's fans. We don't even know if he's a fan of, who he's a fan of at this point. July 28th, 2017, like a jilted woman, Plaintiff again contacted Patreon to make them aware that Herrera's fans were stalking and harassing Plaintiff in person. One of Herrera's fans left a harassing message on a sign-up sheet that Plaintiff made at Comic-Con. Then this same fan called into Herrera's show to talk about the harassment. And again, Patreon doesn't have a contractual relationship with this person that would require them to abide by those terms of service. Dick is not that person and has no control over him, Maddox. People are not property. On separate occasions, plaintiffs' friends and fans have contacted Patreon to advise of the same. Well, that's just dandy. Do the friends and fans have Patreon accounts? Because otherwise, Patreon owes them no duty of care. They barely owe you a duty of care. Your Patreon is piddly. Nevertheless, and despite the foregoing attempts, Patreon did nothing to stop the defendant's conduct and instead tacitly encouraged its continuation for its own financial gain. You don't need a comma there. You don't need one. Therefore, the threats and harassment against plaintiffs continue. Threats and harassment are plural, so they would just continue, not continues, unabated on their pages, while Patreon generates substantial revenue from the defendants' campaigns. Wow. Wow. Patreon boasts about the money its creators generate. Ho, watch out. Patreon is proud of the fact that it makes other people money and is trying to advertise to get more people to help it make its own money. It has a top 50 list on its site, which indicates how much its creators are generating on a month-to-month basis. Defendant Herrera is one of Patreon's top earners. Respect. Respect. Having grossed well over $250,000 since he began using the platform, Defendant Kokonos has also generated a significant amount of income on Patreon in excess of $25,000. Again, respect. Lazarus asks an important question real quick. Can Dick's threat to read the letter constitute blackmail or coercion or something? I am not a law. No, and apparently neither is Landau. That's not a blackmail or coercion. Blackmail or coercion is something where you demand someone do something against the law, typically, in exchange for some sort of compensation. So no, it's not blackmail. There are 3 different fees on Patreon. 1, Patreon takes 5% from any money generated by the creator using the platform. 2, payment processing fees representing the cost of moving funds from the creator's patrons to the creator balance, such as the amount of payment processor charges for each payment processed. Patreon doesn't make money for payment processing fees. If there's a payment processing fee that's charged by, e.g., PayPal, then PayPal makes money from the payment processing fee. Payout fees, the charge for moving funds from the creator balance to the creator's bank or PayPal account. Right. They have 2 fees. They take a 5% flat fee and they take a 1% distribution fee. That's how it goes. Or not a 1%, a small percentage distribution fee. I shouldn't say 1%. Moderator asks, would the letter be considered public disclosure of private facts under the invasion of privacy tort? I don't think so, because the facts aren't private. One of the parties who owned the letter consented to having it read in public. Actually, if we really want to get technical, I would say, when Maddox gave the letter to 80s Girl, he gave her full rights to the letter. He didn't reserve rights. He didn't reserve ownership or give her a limited license. So when he gave that to 80s Girl, all rights transferred to her, and Maddox no longer owns it at all. Keck7Go says, sue PayPal. Yes. If you're watching Landui, maybe you should make a motion for a required joinder of PayPal as an essential party to this. Good job. Good job. Under a conservative estimate, guys, this is a conservative estimate, Patreon generated roughly $50,000 from the activity of defendants Herrera and Kokonos on their platform over just the past year alone. No, that's not a conservative estimate, because if, let's say Dick made $250,000, Patreon takes 5% of that. That's $12,500. That's not anywhere close to $50,000. Even if you combine in Asterios' amount, that doesn't even approach $50,000. That's a quarter of $50,000. And the payment processing fee that they charge is less than the 5% fee. It's like 1.95% or 2.5% or something like that. So you're talking a conservative estimate would be $20,000. A very generous liberal estimate would be $50,000. Okay. Plaintiff Orangutan exchanged multiple emails with Jordan Cope on Patreon. Poor Mr. Cope. Mr. Cope's position with Patreon is creator relations lead, which is a position, comma, you don't need a comma, whereby Mr. Cope is tasked with assigning creators, with assisting creators, comma, such as Plaintiff Azunian. That's weird comma usage, buddy. Jeff M. says consistency is difficult and so are math degrees. We do know that the plaintiff side of the spectrum does have problems with math, both basic and complex math, and in particular, math tests for bachelor's degrees in mathematics. All right. In the emails provided to Mr. Cope, Plaintiff Orangutan gave Mr. Cope numerous examples and information about how third parties were targeting and harassing Plaintiff Blum through defendant Patreon's platform and threatening to rape and kill her. Third parties. You defeat your own argument. At least you're telling the truth in this one, but it's third parties. It's not against Patreon's terms of service to have a fan base be terrible. If we accept this as true, is that if they were actually threatening to rape and kill Jessica Blum, that would be terrible. No one deserves to be actually threatened to be raped and killed. And but again, by all indications that we have, it was Mr. Burgers who was doing that. Who is a Maddox fan. And remember, like Dick pointed out, all the fans are Maddox fans, and Dick has converted them illegally. So let's just remember that everyone making fun of Maddox is a Maddox fan, including me. Further, in these emails, Plaintiff Azunian thoroughly explains to Mr. Cope, can you just imagine having to deal, just take a step back, close your eyes with me for a moment, and imagine having to deal with a Maddox as part of your job on a daily basis. Getting some 25-page email from a whiny Armenian, and then having to try and placate this man who makes your platform no money. Less than even I make Patreon. For the record, I make almost triple Maddox's Patreon right now, and I have resorted to contacting Mr. Cope 0 times. 0 times. Fred Rush says, stop it. I don't know what I'm supposed to stop. What am I supposed to stop? Further in those emails, Plaintiff Orangutan thoroughly explains to Mr. Cope, through numerous examples, probably numbered, how defendants apostrophe Herrera and Kokonos were using the Patreon platform to target, harass, intimidate, and threaten Plaintiff Orangutan and Plaintiff Blum, and just say plaintiffs, and to encourage their fans to do the same, even offering incentives and bonus content to their fans for harassing and targeting plaintiffs apostrophe. You can't do that. Can we add a Maddox as a personality type to the psychological dictionary? Yeah, we'll get that in. Is it DSM-6 that's next? You can't give an incentive. Actually, that's a feature I want. You cannot give an incentive that provides people who don't pledge money access to Patreon bonus content. You can't do that. You have to manually do it outside of the Patreon platform. They're deliberately misrepresenting what Patreon is capable of doing. Everybody take a drink for Cope. Yeah. Pour one in for our homie Jordan Cope. Poor dude doesn't need to deal with this. All right. So you can't offer incentives and bonus content to fans for targeting or harassing plaintiffs apostrophe. You can't do that. It's not possible to do on Patreon. David Friesner says volume good on this one. Okay, man, thanks. Good to know. It's probably just how close I am to the mic, honestly. Or for providing private information of Plaintiff Azunian or his friends, family, or business associates, and to likewise destroy Plaintiff Azunian's Patreon page. So again, this is, I know I'm stopping a lot on this page, and we're on page 8 of 31, but we're only on like page 3 of content. And I apologize for having to stop so much, but this is where the separation of claims between different parties really, really matters, because none of this travesty of a paragraph is able to be done on Patreon. Chap666, I used to be a fan of Maddox. Now I'm a fan of Nikki Rackets. Can Maddox sue you for conversion? Hopefully. But none of this can be done on Patreon's page. And all Patreon has to do to overcome these arguments is to simply say, you literally can't do that. We have no control over it. We have no duty to police these other people that are not Dick Masterson. He can't offer incentives through our platform. They're just wrong. They don't even have to deny that it happened. They can fully admit that all of this stuff happened. That'd be kind of a rude move when it doesn't happen, or at least doesn't happen in the way that it's stated here. But they could do that for their own defense. And they maybe should, in all honesty. But, you know, they've got good lawyers. They'll find out. Plaintiff Orangutan provided Mr. Cope with numerous examples, again, of third parties targeting Plaintiff Blum, threatening rape. They're third parties, Maddox. And disclosing her private information, like her phone number, which is 32... Wait, what is it? What's the area code in California? Anyway, it's 8675309 and whatever area code she's in LA. That's her phone number. There you go. I've disclosed it on live YouTube as well. I didn't do that. That's actually a Tommy Two-Tone song from the 80s. You brilliant man. Using her photograph, which is legal. It's legal. It's unfortunate, but it's legal, right? Maddox? And targeting her with racist death threats. And death threats tend to have an imminence. There's an imminence check in most death threats. Is a person reasonably in fear, because is the person making the threat reasonably capable of carrying it out? And that's a big question with death threats. But they shouldn't be made. We should not make racist death threats. That's just not a thing that people should do online out of common decency. But it doesn't mean that just because someone does it that it's actually illegal. And it certainly doesn't mean that it attaches to a different person. That she was being stalked and harassed. Where was she stalked? Who would ever follow her around? In all honesty, who would do that? The defendants apostrophe Herrera and Coconos, comma... You're almost as bad with commas as you are with apostrophes, LANDAU, and it's getting on my nerves. We're colluding with each other on the platform and releasing podcasts and songs to belittle and humiliate Jessica or Plaintiff Blum and encouraging their fans to harass and stalk her. They weren't colluding on, like, again, on what platform? On Patreon? How do you collude with someone on Patreon? Eat Dead Bunny says, next thing you know, her address is on Baker Street. Plaintiff Azunian exchanged said emails with Cope over the course of several months. Gosh, that poor man. Mr. Cope's reaction was usually that Patreon took these matters seriously. Wait, how is his reaction usually that Patreon took these matters seriously? And that he was sorry to hear about it. And that this information would be passed on to Patreon's trust and safety team. Mr. Cope also indicated to Plaintiff Azunian, Orangutan, that he would be the point of contact at Patreon for these complaints and issues. Yeah, because the worst idea Patreon could possibly have would be to give Maddox direct access to their trust and safety team. Holy cats, they'd have 8 suicides within a week. And would liaise with the team and get back to you with their thoughts. Because a trust and safety team, really, this is a smart setup. A trust and safety team is not the proper person to be talking to an aggrieved party. That should be handled through a liaison. That's how it should be done, so that a person isn't allowed to manipulate and prejudice a trust and safety team directly against another Patreon subscriber. They need that filter. They need it. Every comma was supposed to be an apostrophe on the next line down. Oh my goodness. Okay. Mr. Cope stated that all of the information provided by Plaintiff Orangutan relative to the foregoing had been forwarded to Patreon's trust and safety team, and that he would let Plaintiff Orangutan know when there was news or movement. Such news or resolution was not forthcoming. Because I'm guessing they looked into it and said, this doesn't violate our terms of service. And Mr. Cope and Patreon continued to delay. What were they delaying? We're not going to do anything. Ever is not a delay. If they said, yeah, we'll act later, maybe that's a delay, but you still have to show reliance on that delay for that to matter. Well, that's weird. Tanu Bojangles says commas are just ground apostrophes. They're apostrophes that have been shot down by Bob Marley. They are the sheriff of possession. Okay. They continued to delay and took no action against Defendant Herrera or Defendant Kokonos. So the harassment and threats against both plaintiffs' apostrophe intensified. All right. I'm just getting ready my glass of bourbon here. Give me a second. I said scotch then bourbon. I meant it. Rip in peace, Asterios. Please don't drink any more tonight. Michael Fee, Landui omitted Cope's job description. He helps creators launch a page and engage their fans. He's implying he assists with all issues. That's a good point. That's a good point. All right, so subsection 2, plaintiffs have made a sufficient start in showing that further discovery on the issue of personal jurisdiction over these defendants is warranted. And he footnotes his own subheading, which is a little, I mean, it's just a weird thing to do. 1, quote, should it appear from affidavits submitted in opposition to a motion made under subdivision A or B that facts essential to justify opposition may exist but cannot then be stated, the court may deny the motion, allowing the moving party to assert the objection in responsive pleading, if any, or may order a continuance to permit further affidavits to be obtained or disclosure to be had, and may make such other order as may be just. Here's the problem. All of the facts that you're fishing for, you already had available to you because you're alleging them now prior to discovery. Like, what do you think you're going to get other than what you already have? And right now you're going to attempt to introduce new facts. You're going to do it incorrectly, and it's not going to matter. But let's go with it. Let's go with it. Defendant Patreon has raised $107 million in venture capital for their operations. Good job, Patreon grant writers. Or fund writers, whatever they're called. Of this funding, $60 million was raised by Patreon's lead investors, Thrive Capital, which is a private venture capital firm conducting business in New York with offices at 295 Lafayette Street, New York, 10012. Therefore, at least 55% of Patreon's funding is a result of transactions, connections, and relationships with New York-based companies, without which Patreon would simply not be able to operate. Except, just because the funds came from a New York company doesn't mean that's a significant business tie in New York. It matters where the funds end up, which is in California, right? Right? It also matters what the terms of any sort of agreement state, what law they're operating under, what jurisdiction they would choose in their own contract on between Thrive Capital, if there is a contract between Thrive Capital and Patreon for some sort of money back based on new revenues. Like, you don't just get to pretend that because one of the capital investment firms is in a state that state has jurisdiction. That's not a real thing. And guys, I'll confess, I have pre-read this section. And there's something delightfully missing from it. There's something missing from this section. If you'll notice, let me do a quick scroll through. There are 0 citations to authority until here. And then they get to some more later. But I mean, all of this is just made up. It's just fiction. Actually, saying the word New York automatically gives Landcuck jurisdiction over everything. Oh my gosh. Oh my gosh. All right. So let's move through this. The plaintiff's claims involve elements of Patreon's internal operations. No, they don't. Structure and organization. Nope. Including the manner in which company generates revenues for their respective users and creators. The manner in which they generate revenues for their users and creators is overt. It is a 5% cut of all donations to their creators. That's how they generate money. It's obviously done. That's how they generate revenue. Capital investment is not revenue, so you can't count Thrive Capital's their funding of Patreon at its initial funding phase as revenue. That's not what it is. It is a capital investment. It is a completely different thing. The revenues are plainly generated from their creators and probably through some advertising dollars. Just ridiculous. The latter is the gravamen of plaintiff's complaint against Patreon. Namely, that Patreon favored defendant Herrera above plaintiff Azunian because defendant Herrera was one of their most profitable creators. Shock. Shocking. Just so we're clear, guys. You don't have a right to a private company's services. You don't. You don't at all have a right to a private company service. You may have a breach of contract claim. Maybe, but Patreon owes no duty to keep you on their platform. And their terms of service is not like a contractual obligation that binds them. It binds you. It restricts your actions. So here's the deal. If you are in a restaurant, for example, and you have ordered your lobster, and then Robert Downey Jr. comes in, and he wants to sit down at your table because that's his table, and he pays this restaurant $50,000 a week, and it's your first time going there, they'll throw you out. I would. Every restaurant would. That's just how this works. You don't have a right to be there. You don't have any claim on their services. You have nothing. They can give you your lobster in a box, or they can give you your money back, or they could just kick you out, and you could try and sue them for your money, and you might actually lose. But you don't have a right to Patreon services, and you certainly don't get to have an equal footing with a different creator. If one of Patreon's more profitable creators got preference over me, there's not much I can do about that. And I make more money than you, so I should get preference over you. Maybe I'll complain about you. Just kidding. I don't care. Accordingly, upon information and belief, discovery will reveal, will it, that the foregoing served to create a platform, what? Which taken together comprises the underlying functionality for the company. I don't even know what the foregoing means. Can anybody help? It is through such application that Patreon has a business and was in turn able to market it for additional investment such as Thrive Capital. Guys, this paragraph might have been written while Landau was operating a motor vehicle. I'm not sure. Which after numerous meetings over several months invested $60 million in venture capital. This was confirmed by Patreon in an article by TechCrunch on September 19th, 2017. Notice that was before you filed suit. You had access to this information in your complaint and you refused to include it. Why? Why would you refuse to include it? You had the opportunity. These facts were available to you. You don't get to suddenly claim that these facts were hidden. Footnote 2, okay, TechCrunch article, who cares? Further, Patreon's Crunchbase page indicates this as well. So again, there's another place that tells you exactly where they got this. Has anyone really been far even as decided to use even go want to look like more like? Yeah, that's what his thing sounds like. Thrive Capital is a New York-based venture capital firm with offices located at 295 Lafayette Street, New York, New York. Assuming arguendo that the foregoing is true, you don't take your own statements for the sake of argument. Like you're asserting them factually. You don't say, assuming for the sake of argument everything I said is not a lie. That's not how it works. You have to tell the truth in these. You have to. Plaintiffs believe Patreon's personal jurisdiction defense should fail and that a New York forum is proper. Well, plaintiffs can believe the wrong thing all day. Jesse Samuel Anderson says, will the judge look at all this as closely as you? I don't know. I don't know. In theory, yes, they're supposed to, and they have a clerk staff who's supposed to help with this. So hopefully Hopefully, they will be carefully and thoroughly looking through this. Usually, they do. I don't know. The commercial division should be better at it. That's the one benefit of this being in the commercial division. They should be better at this and going through more thoroughly and making sure all of their arguments are precisely done, because these are sophisticated parties. That's why you're in the commercial division. Further, Patreon plays an active volitional role in designing the arrangement of how its platform operates, namely taking a 5% commission. I mean, I would hope that Patreon plays an active volitional role in designing the arrangement of how its platform operates. They're the people who design how its platform operates. For any money that any user gives, taking 5% commission for any money that any user gives any creator on their platform on a recurring monthly based subscription or per work subscription. That's another way to do it, including up to 40,000 New York-based users and creators, according to the Sullivan Affidavit. And again, like, guys, under this theory that Landau is pushing, Apple would be bound to New York because it has customers in New York. That is not how these things work. That corporations choose in their contractual relationships choice of law and choice of jurisdiction provisions to avoid being hauled into other jurisdictions. That's how it works. Patreon's platform and their direct and active role on a daily basis with their users' money and their creators' careers and financial advancement on their site. Like, I'm laughing at the fact that we have a platform giving people jobs to do stuff like what I'm doing, or to make, weird anime videos and stuff like that. Like, that's just the coolest thing on earth to me. Subjects Patreon to personal jurisdiction in New York? Nope. Like, first of all, Patreon doesn't have a direct and active role on a daily basis with their users' money and creators' careers. Like, that's not a thing that ties them to New York. Patreon doesn't do anything on a daily basis with me, or you, or Dick, or anybody else. Their platform just exists and you access it, similar to Facebook or any other internet page that is put out into the ether that doesn't bind them to a jurisdiction. Patreon's updated terms of use indicate that, quote, you, user or creator, appoint us as your agent to collect and process payments on your behalf. Hey, Landau, you're defeating your personal jurisdiction thing because you're adding an agency element, and that agent is in California where the business is being conducted. And our fee is 5%. As your agent, and who knows what he left out with the ellipse there. As your agent, our receipt of funds from a patron on your behalf is the same as a receipt of funds by you directly, and you will only have recourse against us. Yes, you will only have recourse against us. ... What's it say after that? Did you leave out the part where you choose to be in a California court? Therefore, a major part of Patreon's business is to process payments and collect money from users on behalf of their creators for their 5% commission. Given this dynamic and the type of business that Patreon is running, they are responsible for tens of thousands of transactions involving New York residents on a daily basis, which subjects them to a New York forum. No, it doesn't. As such, contrary to defendant Patreon's argument, the company does indeed have a substantial relationship to New York. This isn't the only argument. And New York has an interest in having an online startup company like Patreon that is responsible for hundreds of thousands of transactions a year among their New York users and creators. That period should be inside the quotes. The court's decision in this case on the issue of personal jurisdiction will impact every one of those 40,000 plus New York residents moving forward, as well as any subsequent New Yorkers who sign up or transact business on Patreon in the future. No, it won't, because they already agreed to do the business to do any legal action in California under California law. They agreed to that when they signed their terms of service creating their account. RickU3220 says Landau thinks the LoLsuit will create precedents. He probably does. Likewise, the court's decision could impact and be used as precedent for any of the other 1 million users on Patreon who do not live in San Francisco. It's not choice of jurisdiction provisions in contracts, even adhesion contracts, which are gross, but they're still valid. Those choice of jurisdiction provisions existed before this lawsuit, and the decision from the court in this case will only impact them if the court follows your theory, because that would blow the choice of law provision and choice of jurisdiction provision that has been a facet of American contract law from the beginning. That would blow that out of the water. You're talking about overriding 200 years of American jurisprudence just because Maddox's feelings got hurt on the internet. In opposing a motion to dismiss, this is a quote, sorry. In opposing a motion to dismiss pursuant to CPLR 3211A8, on the ground that discovery on the issue of personal jurisdiction is necessary, a plaintiff need not make a prima facie showing of jurisdiction, but instead must only set forth a sufficient start and show that its position is not frivolous. Your position is frivolous for everyone, you coward. The jurisdictional issue is likely to be complex. Discovery is therefore desirable, and indeed may be essential, and should quite probably lead to a more accurate judgment than one made solely on the basis of inconclusive preliminary affidavits. Expert Sewer and Drain LLC versus New England Municipal Equipment Company. In the instant case, okay. Let's just address this real quickly. The problem is all of the evidence that you're introducing now should have been introduced in the complaint. You were deficient in that. You failed to include these facts. You did not make a sufficient start in the complaint. Adding them now when they were previously available to you doesn't make you suddenly have a sufficient start. It just doesn't. It just doesn't. In the instant case, as demonstrated by the foregoing, plaintiffs have clearly made a sufficient start in showing that further discovery on the issue of personal jurisdiction over the moving defendants is warranted. No, you haven't. The other aspect, guys. Okay. So when you're trying to state that on discovery you believe you're going to find something, you have to state with particularity what you intend to find. You can't just fish. You have to have a reasonable belief that you're going to tie jurisdiction to Patreon based on something, and you just need to prove it through discovery. But you have to allege what that is. You don't just get to say, there's something out there somewhere that will tie them, and we're going to find it, maybe. You already have the information that you would allegedly need to support your argument. Your argument's just bad. Okay. They quote Expert Sewer again. All right. Here, plaintiff's apostrophe have set forth numerous facts, including those set forth in the affidavit of plaintiff Orangutan, his attorney, and Sullivan, Patreon's general counsel, which thoroughly explain Patreon's substantial business contacts to New York. No, those are incidental business contacts because Patreon is a general, they market generally as a web page. We haven't seen any evidence that they market specifically to New York. You have to market to a forum. The fact that someone from a forum contacts you for your business and you then do business with them does not tie you to that forum. Otherwise, just about every company on earth would be tied to the forum if they simply ship their products through Amazon or UPS or FedEx or have a mail order catalog. Actually, mail order catalogs are probably worse because you have to mail them out in the forum. But just putting up a web page and having people able to come to it does not subject you to personal jurisdiction. And I'm sorry to keep hammering this, but it's such an obviously bad argument on jurisdiction in the context of this type of business. On its own, the facts established in these affidavits and the exhibits annexed thereto demonstrate that facts might exist to support personal jurisdiction over defendant Patreon. What facts? You should lay out what facts might exist that you're looking for, except you don't know because you don't even know how to do personal jurisdiction, which entitles plaintiffs to jurisdictional discovery under CPLR 3211D. This in conjunction with the allegations from plaintiff's complaint, which defendants have intentionally omitted from their motion. It's because they're dumb. And the other facts and exhibits annexed here too is more than sufficient to permit jurisdictional discovery in the case against defendants Patreon and Co. respectively. A litany of case law throughout New York supports this conclusion and relief. Let me, hold on. Let's see what he's got. Advisory essay versus Bakri Telecom PTE. Jurisdictional discovery had to be permitted as to nature of actual knowledge of parent company of telecommunications company and senior management and their responsibilities connected thereto. You haven't alleged that there's a parent company. You haven't even... Patreon has a venture capital firm, which is not a parent company. Patreon, to our knowledge, to anyone's knowledge, to the public's knowledge, is not a subsidiary of a different corporation. This is a terrible case to cite. See also Serchia versus VA Mesa Incorporated. Chap666 says, if Lettuce Jones gets above Maddox, will LANDAU sue Lettuce for $20 million hairs? Hopefully. Hopefully, Lettuce Jones was collecting a significant amount of doll hairs in prison that he could use to pay off that debt. All right, so this case, sales representatives' allegations that clothing manufacturer breached oral agreement and transferred clothing line to affiliated corporation were sufficient to show that facts might exist to justify denial of affiliated corporation's pre-discovery motion to dismiss on jurisdictional grounds. These are not comparable cases at all. In 1981, Unigraphic versus Star Wars Corp. In 1981, the internet barely even existed. Disclosure to enable resolution of the personal jurisdiction issue appropriate, where one of the California-based defendants would be an active defendant in action. New York would be an appropriate forum, and New York, as advertising center of country, would be convenient for those witnesses. No, like... This parenthetical doesn't even make sense in the context of what you're asking. Why are you so... Here's in Star Wars much of the transactions and conduct and discovery related to plaintiffs' claims against Patreon actually occurred in New York. How? Like, how would that even be... It'd be many of the transactions and much of the conduct, by the way, if we're being grammatically correct. Or was done in conjunction with New York parties. What? The individuals purchasing something in New York are not sufficient to tie jurisdiction. Unless you market to a New York market specifically. I can't say that enough. Under these circumstances, jurisdictional discovery is warranted. See Peterson versus Spartan Industries, a 1974 case. I'm sure that'll be relevant. In Peterson, the plaintiffs established that the appellate applied for several permits and received permission to sell and store some of its products in New York, albeit some years before the event alleged in the complaint. Yeah, so again, they're putting their products in New York to be stored. They're creating a contractual relationship with a piece of property in New York. Learn the difference between physical property and metaphysical property. Based on this, the Court of Appeals found that the plaintiffs made a sufficient start and showed their position not to be frivolous. Oxygen Induced says, if I personally omit my best argument, will I win? If you're Landau, maybe, because every argument he makes seems to be bad. If he makes a good one that I find, I will point it out. I haven't seen one. I just haven't seen it. Here, plaintiffs have produced significantly more evidence than that required by any of the foregoing authorities. Nope. They've said things that are largely untrue and entirely inconsequential, and have therefore made a sufficient start and shown their position not to be frivolous. Wherefore, plaintiffs respectfully request the court deny defendant's motion to dismiss without prejudice and allow plaintiffs to conduct discovery on personal jurisdiction. And then we have a legal argument. I am saying jurisdiction. Haven't seen you drink in a while. That's true. All right. Legal analysis. This should be rich. The court may exercise personal jurisdiction over defendant's Patreon and co pursuant to CPLR 302A1. Under New York's long-arm jurisdiction statute, a court may exercise personal jurisdiction over any non-domiciliary who transacts any business within the state. Yeah, it's the meaning of that transacting business thing that matters. By this single act statute, proof of one transaction in New York is sufficient to invoke jurisdiction, so long as the defendant's activities here were purposeful and there is a substantial relationship between the transaction and the claim asserted. You haven't shown purposeful transactions and a substantial relationship between the transaction and the claim asserted. Maddox is in California. Patreon is in California. New York does not have jurisdiction over this. Dominic Peluso says, I'm drunk and I just got here. Can you TLDR? No. Yes, TLDR. LANDAU is terrible at this. How's that? Determining whether long-arm jurisdiction exists under the transact business provision of CPLR 302A1, therefore, is a two-pronged inquiry. Oh, here we go. Gats says, first, hi, Haley. Second, what do you think Maddox will spend his $300 million on? Probably LANDAU, which is the saddest thing I've said all night. Oh, also hashtag Shea Mysterios. Here's a two-pronged inquiry. First, a court must decide, 1, whether the defendant transacts any business in New York, and if so, 2, whether the cause of action arises from such a business transaction. CPLR 302A1 jurisdiction is proper even though the defendant never enters New York, so long as the defendant's activities here were purposeful. The court has explained that purposeful activities are those with which a defendant, through volitional acts, avails itself of the privilege of conducting activities within the forum state, thus invoking the benefits and protections of its laws. You know what undermines that? This is the best part. What undermines that is a specific choice of law and choice of jurisdiction provision for California, you dummy. They're not availing themselves of, like, they're saying that if, listen, contracts are two ways. Contractual relationships are two-way streets. So when Patreon is also restricting its law to California, so when it takes on a New York creator or a New York patron, it's saying that if you have a problem with us, you sue us in California, and if we have a problem with you, we sue you in California. That's how it goes. They're not availing themselves of New York law through these transactions. They're just not. It's obvious from the terms of service that have been cited over and over by Patreon. First, defendant Patreon has raised $107 million in venture capital for their operations. Of this funding, $60 million was raised in 2016-2017 by Patreon's lead investors, Thrive Capital, which is a private venture capital firm conducting business in New York with offices in New York. Therefore, at least 55% of Patreon's funding is a result of transactions, connections, and relationships with New York-based companies, without which Patreon would simply not be able to operate. Therefore, the first prong of the long-arm jurisdiction inquiry is satisfied. Assuming arguendo that you're correct, which you're not, these don't result from that act. And you can't make them to do that by fiction. That doesn't work. But you also don't know the terms of that agreement or where that took place. If Patreon put out there through agents that it was looking for venture capital money, and a venture capital firm in New York enters the California jurisdiction and makes a contract with Patreon, that is not a volitional act in New York, even though it involves a New York-based company. Second, plaintiff's claims involve Patreon's internal operations, how the company is structured and organized, how it generates revenues from their respective users and creators. Therefore, the second prong of the long-arm jurisdiction inquiry is satisfied. How stupid are you? Honestly, like, I'm trying to be calm and be deferential as much as possible and just be joking, but this is blatantly stupid. Look at the two prongs that you just cited, you stupid man. Whether the defendant transacts any business in New York, so you're saying that the venture capital firm transaction occurs in New York. Okay, we'll take it. Whether the cause of the action arises from such a business transaction. The cause of this action does not arise from the New York transaction with Thrive Capital, you dumb person. You're terrible at this. You're doing this on purpose because you're trying to cost everybody money. You do it in every case that you do. You're a garbage attorney. Get retired. Dominic Peluso says, assuming arguendo, poo and pee. Asterios has apparently died and reincarnated and taken over the body of Dominic Peluso. Welcome to the stream, buddy. Also, hashtag shame Asterios. The latter is the gravamen of plaintiff's complaint against Patreon. Using gravamen twice doesn't make you important. Namely, that Patreon favored defendant Herrera above plaintiff Azunian because defendant Herrera was one of their most profitable creators. How does that second prong relate to your first prong, you moron? A litany of Court of Appeals case law supports personal jurisdiction over Patreon only if you can't read. Based on the foregoing transactions, generally these cases demonstrate that the Court of Appeals has upheld long-arm jurisdiction over a non-domiciliary where the claim had the requisite nexus to an in-state transaction. An in-state transaction related to the claim, you liar. Say the rest of it. Say the rest of it. jurisdiction over Massachusetts resident for breach of an employment contract entered into in New York. That was a breach over the same claim. It happened in New York, and it was a breach of the claim that happened in New York. Purposeful activities engaged in by the defendant in this state in connection with the sale of its products in the New York market. Connected with the sale of its products in the New York market. Not connected with venture capital money. More recent Court of Appeals cases. Why is this a subsection? Directly applicable to the instant issue. C. Cruder. The plaintiff was not required to establish a formal agency relationship between New York licensed corporation, the Texas defendants, but only had to convince the court the alleged agent engaged in purposeful activities in New York in relation to the plaintiff's transaction with benefit of and with knowledge and consent of the Texas defendants, and that the Texas defendants exercised some control in the matter over the alleged agent. How is that at all related to this case? See, Lissy? I don't know what that is. Claims brought against New York Bank by Israeli residents, shout out to Maxwell Kimball, who were injured or whose family members were killed in a series of terrorist rocket attacks on civilians in Israel to satisfy the arise from prong in New York's long arm statute. Again, it has to arise from the transaction that you're claiming. Former bank employee's action seeking compensation allegedly owed him for his role in foreign investment program of government-owned enterprises in Brazil. Shareholder agreement and 2 other contracts outlining employees' compensation were negotiated and executed in New York. And again, the second prong relates to a breach of those contracts in New York. Okay. Patreon plays an active volitional role in designing the arrangement of how its platform operates, namely taking 5% commission for any money that any user gives to a creator on their platform, including up to 40,000 daily transactions involving New York-based users and creators who use their platform. Further, Patreon's updated terms of use even indicate the direct and active role they take on behalf of their users and creators. Quote, as your agents, our receipt of funds from a Patreon on your behalf is the same as a receipt of funds by you directly, and you will only have recourse against us. What's it say after that? I really, really want to know, but I'm not going to look it up. But it doesn't matter, because them taking money from someone isn't entering under New York jurisdiction. Minimum contacts, therefore, also exist because defendant Patreon is purposefully availing itself of the privilege of conducting activities within New York through its financing, payment processing, and banking services for its users and creators, except that its financing, payment processing, and banking services aren't located in New York. At least you haven't alleged that. Maybe you could have alleged that if it were true, but I don't think it is, because I think you would have put it in here, but your competence knows bounds. Oxygen-induced says, Kevin, quote, I sue everybody, apostrophe, and copy and paste LANDAU, apostrophe, hashtag Shea Mysterios. Andy Polo, finally got my wife and daughter put to bed, poured a glass of rye whiskey, and joined the stream. Cheers, Nick. Welcome to the stream, buddy. Glad to have you. Thanks for the super chat. Now let's keep moving here. There's financing, payment processing, and banking services for its users and creators, and through its solicitation and active encouragement of bringing new users and creators to the platform. I'm not going to say it again. The Court of Appeals recently spoke of such an arrangement in Al Rashid versus Pictet and C. And found that the defendant's maintenance and repeated use of a New York correspondent bank account, quote, to achieve the wrong complained of in this suit. To achieve the wrong complained of in this suit satisfies the minimum contacts component of the due process inquiry. Therefore, the Court of Appeals applies CPLR 3. Did you forget to end the... Okay, here's the thing. Again, what New York correspondent bank account? You haven't even alleged this. You haven't even alleged that they have a New York bank account. Again, you're trying to analogize things that are not analogous. Analogize? Analogize? Analog? Make an analog of? I don't even know. I don't know anything anymore. They apply CPLR 302A1 to foreign banks that cause tortious injury through the frequent use of correspondent banking arrangements with New York banks. This rule applied to corporations engaged in similar banking transactions through correspondent New York banks, such as Patreon here. Patreon isn't a correspondent New York bank. They're a California operation. They're not a bank. Banks are regulated in specific ways. Patreon is not engaged in banking. With its users and creators, see Indo-Suez International Financial versus National Reserve Bank. Personal jurisdiction existed because the parties had established payment in 5 prior similar transactions through a New York bank. Not payments to New York banks. I don't know if... guys, I don't know what he's actually alleging anymore, but I think if I take away the brain that I have and I just like put it in a blender and put it back in, I got that he thinks that because Patreon sends money to the banks of customers in New York, that is the same thing as being a correspondent banking service, but it's not. Okay. Repeated use by Lebanese Bank of New York correspondent account showed a transaction of business. A New York correspondent account is an account at a bank in New York. Personal jurisdiction conferred where the defendant, a Spanish winery, made an oral agreement in Spain with the plaintiff, a New York broker, to find a U.S. distributor for the importation of defendant's wine into the U.S., and in return, the defendant agreed to pay commissions to the plaintiff on the sales made to the distributor, which the defendant failed to do. So again, you're failing the second prong. Again, all of your citations are different than what you've asserted, because what you've asserted is one prong and then a second prong, and they're unrelated to each other because you can't read or reason. Therefore, purposeful availment has clearly occurred in this case. Again, such a strong statement. An assertion of jurisdiction here also complies with due process. As such, Patreon's New York-based financial partners, responsible for funding the vast majority of its business in conjunction with Patreon's platforms in a direct and active role, further subjects Patreon to personal jurisdiction in New York. No. Period, space, space, period, space. Finally, the court's decision in this case on the personal jurisdiction issue, you don't need a comma there, will impact every one of the 40,000 New York residents who transact business with Patreon. No, they're already affected by their own agreement, as well as any subsequent New Yorkers who sign up or transact business on Patreon in the future. Oxygen Deuce says, I'm using a VPN through New York. Now I'm suing you. Hashtag Shea Mysterios. Likewise, the court's decision could impact and be used as precedent for any of the other 1 million users on Patreon's platform. No, it honestly, it can't. Who do not live in San Francisco. See Wilson versus Danta Supra. The plaintiff's claim arose from one component of a much broader business transaction. This didn't arise from any component of a business transaction. See also Hallis versus Dick's Sporting Goods, where the manufacturer of a Hunter's Tree stand sold its product through an exclusive distributorship with Dick's Sporting Goods, which has retail stores in 36 states, including New York. Yes, their product physically went to New York in an exclusive way. They intentionally chose Dick's Sporting Goods because of its businesses, which have brick-and-mortar stores in New York. The court found that although the product was not designed specifically for use in New York, the manufacturer could have reasonably foreseen, as a result of its distributorship arrangement, that his product would have an impact in any state where Dick's distributed the product, including New York. I'm not going to read his footnote because I can't take it. It's too stupid. Patreon's website is highly interactive. Okay, guys, I need to take a break from dumbness for just a second. And I'm going to go to this case because this case is really important. Because if you remember, and I don't know if he ends up getting to this. I don't know if he ends up getting to this in his argument. But one of the key issues that he hasn't gotten to yet in Patreon's claim against jurisdiction is his choice of law and choice of jurisdiction provision in Patreon's terms of service, right? So in their contractual agreement. So here's the case. This is a pretty important case. It was decided by the Appellate Division of New York's Second Department. Jeff M. says research Flatisterios. So this is Premium Risk Group versus Legion Insurance Company. This is a very short opinion. It's only this long, a page and not even a page. Not even a page. Okay, so I'm going to read it all real quick and follow along with me. In an action inter alia to recover damages for breach of contract, Inter alia, I said it inappropriately in the other stream because I couldn't think of it, but inter alia means among other things. The plaintiffs appeal from an order of the Supreme Court, Nassau County, dated January 17th, 2001, which granted the motion of the defendants' mutual holdings and mutual indemnity pursuant to CPLR 3211 to dismiss the complaint insofar as asserted against them. So they moved to dismiss a complaint asserted against them based on lack of jurisdiction. The plaintiffs commenced this action alleging, among other things, breach of a shareholders' agreement. The defendants' mutual holding and mutual indemnity, hereinafter referred to collectively as the Bermuda defendants, moved to dismiss the complaint insofar as asserted against them on the ground, among others, that a forum selection clause in the shareholders' agreement and in a deductible reimbursement policy provided that all disputes would be resolved in Bermuda under Bermuda law. The Supreme Court granted the motion, and we affirm. Here's why they affirm. So this is the exact same thing that Patreon has done. This likely overrides common law personal jurisdiction under the long-arm statute. Contractual forum selection clauses are prima facie valid and enforceable unless it is shown by the challenging party to be unreasonable, unjust, in contravention of public policy, invalid due to fraud or overreaching, or to shown that a trial in the selected forum be so gravely difficult that the challenging party would, for all practical purposes, be deprived of its day in court. There's a 5-prong test. Maddox fails every single one of them. Every single one of them. Enforcement of forum selection clauses provides certainty and predictability in resolving disputes, particularly those involving international business agreements. And international business agreements are similar to forum state agreements, but, you know, not directly comparable, obviously, but it doesn't really matter. Here, because the plaintiffs failed to demonstrate any basis for denying enforcement of the clauses, the Supreme Court properly granted the motion of the Bermuda defendants to dismiss the complaint insofar as asserted against them. They have not given a single reason why you can overcome the Patreon terms of service agreement, that all of these things will be decided in a San Francisco court. They haven't done a single thing to overcome that. Those are prima facie, which means on the face of it valid, which means the presumption is that it's valid, which means that you have the burden as the plaintiff to overcome that defense, and they haven't done it. As demonstrated by the foregoing, Patreon has transacts a substantial amount of business in New York and has sufficient contacts. Therefore, defendant argument is largely irrelevant. There's an apostrophe on defendants before argument, and how is it irrelevant, and which argument are you talking about? Further, as demonstrated above, Patreon operates a highly interactive website which allows creators to offer merchandise for sale. Nope. And users to pay for a monthly recurring subscription. That part is true. Merchandise for sale is not true. You can't conduct individual transactions on Patreon, to my knowledge. Maybe I'm wrong. Maybe I'm wrong. Pretty sure there's not a store. A defendant's operation of a highly interactive website that offers merchandise for sale to consumers in New York and shipment in such merchandise to their sufficiently demonstrates the defendant's purposeful availment of the benefits of transacting business in New York. I mean, I can't... How many times do I have to say he's wrong? Can I be excused? See Rovio Entertainment Limited versus All-Star Vending Incorporated. California video game company advertised, marketed, and promoted and sold purportedly infringing products to New York customers via interactive websites. See Thomas Pubco versus Industrial Quick Search. Non-resident publisher of a business directory operated interactive website directed in part to consumer users in New York. Had sufficient contacts with New York. And let's see their stupid footnote. Citigroup versus City Holding Company. Foreign defendant transacted business in New York when its website allowed New York customers to apply for loans. Yeah. I mean, come on. Electronically chat with an online representative and email questions to the defendant. See Hisin 10 Enterprise USA Incorporated versus Clark Enterprises. The defendant's websites enabled the viewer to purchase the exercise machines online, download an order form and an application to become an independent affiliate. So again, to start conducting business as an agent in the forum state and ask questions of an online representative. At the very least, the websites are highly interactive. You're not. You notice you're not asking questions of an online representative through Patreon's website. You have to do that through an email, which you did 5,000 times to poor Jordan Cope. This ought to be rich, by the way. The court has personal jurisdiction over Patreon's employee, Jordan Cope. This is, like, honestly, Jordan Cope, as much as I love Asterios and think that he shouldn't be involved in this, and as much as Bozer shouldn't be involved in this, well, Bozer's probably in the same spot. Jordan Cope has nothing to do with this. Nothing to do with this. In Chloe versus Queen Bee of Beverly Hills, LLC, the Second Circuit Court of Appeals found that the single act of an out-of-state defendant employee shipping an item into New York combined with his employer's extensive business activity involving New York gave rise to personal jurisdiction over the employee in New York. Here, as in Chloe, the sales activity of Patreon conducted by means of the internet serves as a predicate for long-arm jurisdiction over Cope in this case. Again, Chloe is shipping something physically to the forum state, and its employer has significant business contacts, and I'm betting that you left out the fact that the alleged cause of action came out of those facts. Windows 95 says, hashtag Shea Mysterios, hashtag Ble is Bay, hashtag Amelie loves you, hashtag, and also hashtag Shea Mysterios. Plaintiff. Can't even read anymore. Plaintiff never assented to the terms of use contained in Exhibit 3. He didn't? He didn't. Before proceeding to Patreon's argument and the terms of use contained in Plaintiff Azunian's orangutan's purported agreement with Patreon, the court must first determine whether there is a binding contract between the parties. The creation of online contracts, quote, has not fundamentally changed the principles of contract. Okay. To create a binding contract, there must be a manifestation of mutual assent sufficiently definite to assure that the parties are truly in agreement with respect to all material terms. This dork thinks he's going to argue down adhesion contracts in New York and not in the Supreme Court, despite the fact that adhesion contracts are used and not assented to by anybody constantly and are constantly upheld. Constantly upheld by the courts. To assure that the parties are truly in agreement with respect to all material terms. There must be an offer followed by an acceptance. In regard to online contracts, courts look for evidence that a website user had an actual or constructive notice of the terms using the website. Yeah, it's that button you click that says, I agree to the terms. Where the supposed assent to terms is mostly passive, as it usually is online, courts seek to know, quote, whether a reasonably prudent offeree would be on notice of the term at issue and whether the terms of the agreement were, quote, reasonably communicated to the user. When they pop up in giant letters on your screen and you have to read through them and you have to click an accept button that's at the bottom, the court presumes that you assent. It's gross, but it's the law. Deal with it. Moderator, please. Please send me aspirin. Okay, let's see his footnote. Resorb Networks Incorporated is a recent case under a substantially familiar fact pattern as the instant case. I highly doubt that. Where the defendant internet company failed to establish the plaintiff website user's assent to an arbitration agreement. See also Berkson for a thorough discussion of the issues and facts presented herein. Wow. Defendant Patreon contends. Corey Jamnick says, I can't believe I bought Asterios's ellipses, apostrophe ellipse, period. Shea Mysterios. Hashtag Shea Mysterios. Wow. Defendant Patreon contends that plaintiff became a registered Patreon user on June 3rd, 2016, and that in, quote, registering to use plaintiff services, quote, explicitly agreed to Patreon's terms of use, end quote, by checking a box on Patreon's sign-up page. Yeah, that's what happens. Again, I don't like it, but that's what happens, and the courts are consistent on saying that this is correct. Patreon points to a purported blank sign-up page that it currently uses and represents this to the court, that Plaintiff Azunian explicitly agreed to their terms of use. He did. When he clicked accept, He explicitly agreed. There are other platforms. By the way, if you guys don't know, and you probably don't, because why would you waste your time spending studying this? But when you're trying to overcome an adhesion contract, there are ways to do it. And one of the most important ways to do that is to say that this is an exclusive product that can only be gotten through their adhesion contract, which you are not allowed to negotiate, and that it excludes your ability to participate in purchasing this product or using this product or using this agreement. Patreon exists. Other funding sites exist. YouTube exists. YouTube is a funding site for this type of stuff. YouTube is a significant portion of Maddox's money, or well, it was until people stopped watching his videos. There are other ways. You can create your own. You can create your own payment system. Anthony Salamanca says, love your videos, dude. You've inspired me to look into a law degree after I finish the one I'm working on now. Well, good luck, buddy. It's a long road, and the first year really sucks, but it's a lot of fun. Don't let anyone distract you. If that's what you want to do, do it. Talk to a lawyer who likes being a lawyer. Don't talk to other lawyers and ask them, because they'll all tell you, don't do it. Just kill yourself instead. But no, talk to a lawyer who has fun doing it and is successful, and they'll encourage you. It's a cool job. You get to do some fun stuff. Patreon points. Okay, yeah. Explicitly agree to their terms of use contained in Exhibit 3. Based on this blank sign-up page, Patreon fails to indicate whether or not Plaintiff Azunian received the terms of use contained in Exhibit 3 when he originally signed up for Patreon, or if he was provided with any notice of these terms of use. No, they just said in an affidavit that he did. They can't. Okay. Instead, Patreon, assumes, without any foundation, Landau, let me help you. Instead, Patreon assumes without any foundation, Actually, I don't even know if that second comma is necessary. That plaintiff orangutan assented to the terms of use contained in Exhibit 3 and agreed to arbitrate any controversy involving Patreon in a venue in San Francisco under the terms stated in Patreon's terms of use contained in Exhibit 3. You're getting redundant. Thereby, this is all one sentence. Guys, this is a disaster. Thereby foregoing his right to sue Patreon in a court of law, space, in addition to a variety of other rights, which Patreon's current terms of use contained in Exhibit 3 substantially restrict. You needed a comma after terms of use. Patreon's argument is disingenuous. Well, that's a bold statement. Drink for the balls on Landau for calling someone else's argument disingenuous. That is... Ooh. Okay. If you click I agree, you do. That's the law. I don't know what to do about that, Dominic. I don't know what to do. Okay, I won't. Hashtag Shea Mysterios. Patreon attempts to minimize the fact in a footnote that they have submitted two completely different terms of use annexed to Sullivan's affidavit. The terms of use contained in Exhibit 2, which is not referred to in its motion, were in effect when Plaintiff Azunian signed up to use Patreon June 3rd, 2016. However, the terms of use contained in Exhibit 3, which Patreon bases its motion on, went into effect on November 1st, 2016, 5 months after Plaintiff Azunian signed up. Patreon does not indicate that Plaintiff Azunian was ever notified or assented to the current terms of use contained in Exhibit 3. He was, and he did. He continued to use the platform. It's your... I hate to say this. Guys, this makes me feel dirty because I hate these contracts. I hate them. But it is the user's responsibility to keep up on terms of use. And I'm betting that Patreon sent out an email on November 1st, 2016 to all current Patreon users that they were updating their terms of use and that continued use would manifest assent to the platform. Okay. The reason for this is simple, because Plaintiff Azunian was neither notified nor assented to the November 2016 terms of use. Therefore, plaintiff is not bound by such a document. But he is. The terms of use contained in Exhibit 2 does not require plaintiff to submit to arbitration. That's not, I mean, that is an argument But the other part of the argument is that the jurisdiction requirement, is that not in there? Let's see. Let's see what he says. I mean, if he doesn't argue against that, if he doesn't argue that that the California law, choice of forum and choice of law provisions are in there, then he won't win. A party is not obligated to arbitrate unless he or she consented to do so. Okay. When one party seeks to compel the other to arbitrate their disputes, the court first determines whether the parties made a valid arbitration agreement. I would say they did, and so would every court on earth. The party seeking arbitration has a burden of establishing an agreement to arbitrate, which they did. Corey Jamnick says, you doing videos on LANDAU's other cases ever? Yes, Corey, they were supposed to happen this week, but I got swamped with personal, with stuff at my own law firm. Some emergency issues came up that I had to deal with, and I just did not have time to put together a great video. And I want that video to be thorough and fantastic, and I don't want to, you know, slough it off. So it will be well researched, and yes, I will be doing a video, possibly a live stream on it. So please stay tuned, but I want to make sure it gets done correctly. And yes, I do have his, I also have in my possession his DUI cases, and we will do an anatomy of how to lose a DUI case. Starting from the pullover, starting from the driving, we will do an anatomy of how to lose a DUI case via Kevin Landau. So those should be fun videos. Here, the arbitration agreement contained in the terms of use in Exhibit 2 does not mandate arbitration, instead states and is unconscionable under California law. That's not a coherent thought or sentence. California Civil Procedure Code 16770.5a states as follows: if the court, as a matter of law, finds the contract or any clause of the contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result. Unconscionability analysis begins with an inquiry into whether the contract is one of adhesion. And adhesion contracts are gross. The term contract of adhesion signifies a standardized contract which, imposed and drafted by the party of superior bargaining strength, relegates to the subscribing party only the opportunity to adhere to the contract or reject it. Yep, they're nasty. Matt Tobin says, fight those fires, they'll burn you to death. Hashtag Shea Mysterios. Generally speaking, there are two judicially imposed limitations on the enforcement of adhesion contracts or provisions thereof. The first is that such a contract or provision which does not fall within the reasonable expectations of the weaker or adhering party will not be enforced against him. The second, a principle of equity applicable to all contracts generally, is that a contract or provision, even if consistent with the reasonable expectations of the parties, will be denied enforcement if, considered in its context, it is unduly oppressive or unconscionable. This should be rich. How are you going for the DUI video now, please? Okay, so I can do the DUI video probably sooner than the other videos, because the other videos just involve doing a lot of research. So that's what's taking so long. I'll do the DUI video sooner. Thanks for the super chat. If someone wants to answer this, would you like a live stream of the DUI video? You can ask questions and all that stuff if you want. Unconscionability is a big word, Puma Pants. It means that, Puma Pants. Guys, don't have funny names. It means that something is unconscionable or egregious or terrible. Is it normal to lay out every basic definition like what an adhesion contract is to a commercial court, or is he trying to lawsplain? No, it is normal you're trying to show that you're using it properly. That's the real thing. Stop shaming Asterios. That's enough. He hasn't won yet. Is Asterios still alive? Someone check on him. All right. Nick, you obviously don't understand international dog bite law. It's even higher up than any maritime admiralty law. Yeah, but does he understand bird law? Live streams are always fun and quality over speed. Okay, we're going to keep going. In the instant case, applying the above principles, there is little dispute. I'm going to have to do a drinking game every time that Landau is overly presumptuous. That the arbitration agreement is adhesive. Oh, I thought he was going to say that it's unconscionable. Sorry. So yeah, he's right. It is an adhesion contract. Absolutely. The arbitration agreement was imposed on plaintiff as a condition of using Patreon. First, the arbitration agreement allows Patreon to submit to arbitration if they choose to. Second, it requires plaintiff to pay the cost of the arbitration if the claim is over $10,000. The arbitration... Yeah, okay. What's wrong with this? The arbitration agreement is completely one-sided in favor of Patreon, space, comma... No, that's not a space. And plaintiff has no ability to negotiate its terms, and certain conditions would limit or eliminate Patreon's or plaintiff's substantive rights, which plaintiff would otherwise have in litigation if the dispute were decided in court. So here's a problem for you, though. If Patreon rectified the unconscionability that you're alleging, if it's indeed unconscionable, and Maddox is now under that agreement, then this is entirely pointless. This is frivolous. Copy-paste the documents into Google Docs and have Patreonies write questions onto the document for you. That's a good idea. Maybe we'll do that. Let's see. The arbitration agreement is completely one-sided in favor of Patreon. Plaintiff has no ability to negotiate its terms, and certain conditions would limit or eliminate plaintiff's substantive rights, which plaintiff would otherwise have in litigation if the disputes were decided in court. Further, discovery is limited under this agreement. There is substantial added costs and fees in arbitration under the American Arbitration Association rules, including paying the arbitrator an hourly wage or an hourly rate. Damages are limited under this arbitration agreement, and plaintiff may not seek statutorily imposed remedies such as punitive damages, costs, and attorney's fees. Under California law, Patreon arbitration agreement is therefore unconscionable. No, not necessarily, and the court may refuse to enforce it. The California court may refuse to enforce it. Dummy, you cited California civil procedure law in a New York court. The California court would have to fail to enforce the arbitration agreement that was made in California under California law, under which all disputes with Patreon must be decided in court in California, which is more convenient for both Maddox and Patreon. You failed to address the most important parts of this stupid agreement. Arbitration agreement may not limit statutorily imposed remedies such as punitive damages and attorney's fees. Okay, does it do that? You haven't actually alleged that it does that. When parties agree to arbitrate statutory claims, they also implicitly agree, absent express language to the contrary, to such procedures as are necessary to vindicate that claim. Okay. Further, Patreon's arbitration agreement would require plaintiff to waive certain other rights and benefits, such as being a class participant in a class action, and will require this dispute to be resolved in a private forum, which contravenes the intent and spirit of general business law 349, 350, and then see California Civil Code 3513. Anyone may waive the advantage of a law intended solely for his benefit, but a law established for a public reason cannot be contravened by a private agreement. Okay, were he bringing a class action lawsuit, he might have a claim, but he doesn't. Finally, if the what are you doing? Finally, if the. Accordingly, Patreon's arbitration agreement is adhesive. Why are all those A's capitalized? APAA. Oh, he's trying to slip in secret messages. People who slip secret messages into documents are cool, and Landau knows that. And unconscionable. No. Like, yeah. Okay. And the court should refuse to enforce it. The California court maybe should. Bring it in California. And again, you're citing California. You're citing California law. There's little dispute that it is. It was imposed on employees as a condition of employment, and there was no opportunity to negotiate. You should be citing New York law. If you're arguing that New York has jurisdiction, you should say why New York should invalidate the unconscionable contract. New York. You're in New York. You're arguing that New York has jurisdiction. Everything you've said is New York, and suddenly you're citing California law. It doesn't make any sense. The unconscionable, like if New York has an interest in taking this case and protecting someone under New York law, then New York would have the interest in undoing an unjust arbitration clause in a contract of adhesion. The unconscionable one-sidedness of the arbitration agreement is compounded in this case by the fact that it does not permit the full recovery of damages for employees while placing no such restriction on the employer. What do you want? Oh. It's, what kind? There's a very important pause that I have to take here. This is the White and McKay. You like that?
Yeah.
Not orange drink, guys.
Better not be giving that to our 5-year-old. Clay's mad that you're taking over his drinking game. Watch it.
How am I taking over Clay's drinking game?
I don't know. Watch it.
Ooh. So that's Midnight Scotch Lady Rekieta, my favorite addition to the show. And here we are. So, little disruptive, but back to where I was. The unconscionable one-sidedness of the arbitration agreement is compounded in this case by the fact that it does not permit the full recovery of damages for employees while placing no such restriction on the employer. Lydia Schewitz says, for your wife, cheers to you both. Thank you, Lydia. And Matt Tobin says, wife who drinks the brown stuff, lucky man. That sounds, in a way, disgusting. Fish Monster says, your wife is a manlier drinker than Asterios. Rip Asterios. Poor guy. Okay. The court had refused to enforce a provision in an arbitration agreement between a doctor and a patient that would allow a trial de novo if the arbitrator's award was $25,000 or greater. The Psycha court reasoned that such a clause was tantamount to making arbitration binding when the patient lost the arbitration, but not binding if the patient won a significant money judgment. Wow. Wow. Plaintiff has stated a cause of action for negligent failure to warn. Guys, you notice what he's like? He left out the choice of law and choice of jurisdiction provisions. Should you? My wife wants me to go to bed. What do? Buddy, that's a call only you can make. I don't know how to answer that without getting you killed. Go to bed and bring your phone and have her watch me too. Oxygen induced. Should I join the Freemasons? Hashtag Asterios died. Oh man, rip Asterios and his liver. Guys, Landau failed to argue against one of Patreon's key arguments that all of this has to be decided under California law in a California court in San Francisco. Maddox agreed to it. He didn't state that even if the arbitration clause is unconscionable, and we can take Landau's argument and say, okay, let's say the arbitration clause is unconscionable. Then they just refuse to enforce the arbitration clause. If the judge refuses to enforce the entire contract, which they stated was a possible remedy, then you don't have a cause of action against Patreon because the entire contract is voidable. So why would you fail to argue against one of the most important pieces of the terms of service? Maddox, he failed to argue against a key argument from one of your defendants. Why are you paying this guy? Keep paying him, please. This is constantly entertaining. It has long been a rule that a plaintiff may recover in strict products liability or negligence for a manufacturer's failure to warn of risks and dangers associated with the use of its product. Oh my gosh. This is the dumbest legal theory you could have. Like strict products liability because someone on Patreon, actually someone not on Patreon, decided to make fun of you and they watched someone else on Patreon. That's going to be your products liability link? What is wrong with you? The duty generally extends to warning customers of dangers resulting from the foreseeable use of its products. I guarantee you, Patreon.com did not foresee a crowd as loyal, as rowdy, and as flipping hilarious as the Dick Show audience. I guarantee Patreon could not have foreseen that, and there's no way that would be considered foreseeable from their platform, you dummy. Which the manufacturer knew or should have known, and liability may be imposed based on either the complete failure to warn of a particular hazard. You're going to get death threats if you're on Patreon, guys. You're going to get death threats from the Dick Show fans if you're on Patreon. Or the inclusion of warnings that are insufficient. Is it possible Landau is a dickhead? He's just hosing Maddox for all of his money. You know, at this point, I don't put anything out. Landau, like if he's charging Maddox, it's borderline criminal at this point. I won't say it is criminal because that might be libel per se or slander per se, right? But, I mean, this is bad work. This is bad work. Like, okay, lawyer break. It's okay to be wrong as a lawyer. Like, lawyers are wrong all the time. We miss things all the time. We make strategic decisions that leave out stuff. We decide that maybe this isn't the right path to argument. This isn't the right choice of law. We leave out certain things, not things that would be factually damaging or something like that. It's not a shady leave out, but we just choose different strategies for different things. That's okay. Choosing not to argue against a major point in your opposition's memorandum gives the court only one side of that argument. And that is terrifying to think that an attorney would leave that out. I don't know any attorney who would actually ignore an entire point where if the court found it to be correct, would completely dismiss the case. Like failing to argue that is tantamount to malpractice. What do you think of Dick's theory that Landau is literally just fleecing Maddox and has no intention of actually winning? That's possible. That is entirely possible. I don't know. If it really, the hard part is what conversation Landau had with Maddox. Maybe he was upfront with him and said, I don't know if I can win. You're going to dump a lot of money into this case and we're probably not going to win anything. And then Maddox says, that's fine. I'm in it for the spite. Okay. Like, I guess Landau can run with that. I don't think that happened. It doesn't seem like Maddox would do that. Like, he makes bad decisions, but that's a really bad one. I don't know. Okay, the adequacy of the instruction or warning is generally a question of fact to be determined at trial and is not ordinarily susceptible to the drastic remedy of summary judgment. You don't have a products liability claim, you dork. You don't. You don't. You can't stretch the law that far. Like, Defendant Patreon contends that plaintiff's claim is barred because plaintiff was already aware of the risks of using Patreon. Yeah, because he's been on the internet and he has done this to other people because he's a coward. Patreon's contention is baseless and negates the allegations pled in plaintiff's complaint and the July 2016 terms of use that plaintiff assented to. Patreon's contention is baseless. No, your inclusion of Patreon is baseless. Just like your inclusion of Univision and Almacigo is baseless, and you got slapped down for that. I hope you get slapped down here. I hope you get sanctions at this point. Fred Rush MD says 1 to 10 scale odds of LANDAU getting sanctioned, etc. for all this garbage. Every single motion he's closer to a sanction because they're all disgusting. I don't know. I am nowhere near familiar enough with New York to give a scale odds, but his continued pursuit of pushing falsehoods on the court in Almaciga and then doing it again in this case after being warned in Almaciga how close he came to sanctions is crazy. It's insane that he keeps this up. It is very possible that he does get sanctions because of it. So I think it's about time. I think maybe, I mean, guys have their licenses suspended for less than this, in all honesty. Here in his complaint, plaintiff Orangutan alleged that he had a Patreon account and was never warned by Patreon about how third parties were permitted to target victims and other creators. They weren't permitted to. And Patreon has no control over third parties or duty to warn about someone outside of their control through their use of Patreon, incentivizing and charging money to fans to stalk, harass, and threaten individuals like plaintiffs apostrophe herein, in an attempt to destroy their personal and professional lives. Further, Patreon never warned plaintiff Orangutan that it applied different criteria to its creators and treated them differently based upon how financially successful the individual creator was. That's something you have claimed and have not shown. That's just your baseless, bald assertion. Patreon actually has a term and metric it uses called financially successful creators. Patreon has close to 1 million users on its platform. However, less than 50 creators earn $150,000 per year, which is where Patreon makes a majority of its fees. Defendant Herrera is one of them. That's something you're citing your own complaint as justification. Landau is untouchable. He donates to the Clinton Foundation. Hopefully he doesn't have any information that would lead to the arrest of Hillary Clinton. You might have gone over this, but what do sanctions entail exactly? Alex Nevis, that's a good question. Sanctions can range from anywhere from dismissal of the case entirely. They can also be monetary penalties where, like Maddox would have to pay the legal fees, or even Landau would have to pay the legal fees of the other parties. It really depends on what the court deems just, but sanctions have a wide range. But they're penalties, and the court has flexibility on what those penalties are, and they can exercise their discretion. Okay. Likewise, Patreon failed to warn plaintiff Blum about information it obtained. Patreon does Jessica Irene Blum have a Patreon account? How would they have any duty without having a contractual relationship with her? They have no duty at all, such as how defendants Herrera, Kokonos, and thousands of their fans through its platform were targeted. And none of it was done through Patreon, by the way. None of it was done through Patreon. Stalking, harassing, and advocating threats to rape and murder. None of that was done through Patreon, and you haven't even asserted that Blum is a Patreon user, much less a creator. They had no contractual relationship. They have no duty to inform. Negligence and strict liability still involve duty. There's still a duty that has to be imposed, and if you don't have a duty, you can't be held liable. Patreon's duty to warn plaintiff Blum or plaintiff Orangutan under these circumstances does not exist. That's where he should have ended the paragraph. Would not require Patreon to remove any user content or otherwise affect how it publishes or monitors such content. So, further, treating plaintiff Orangutan the same as defendant Herrera, both creators on the platform, has nothing to do with content. They don't have to do that, though. YouTube doesn't do that. YouTube has a subscriber tier. Higher subscriber people get more benefits. Twitch, the more subscribers you have, the better financial relationship you have with Twitch. And that's not just related to internet platforms. If you talk to investment firms, trust services, the more money that you have with those firms, the better benefits you are, and actually the lower pricing you get. Maddox doesn't know this because Maddox doesn't have any money, but Landau should, because he takes money from people unjustly all the time. And by unjustly, I mean through poor representation and losing their cases. Don't misconstrue it as saying I'm saying he's criminal. I'm just saying he's incompetent. Everybody treats the... I shouldn't say every company, but the many companies treat different customers differently based on how much money they bring in. It's the smartest business play you could possibly make. You know, if you buy a skybox at a ballpark, you get way better experience than you do buying the nosebleed seats. Oh my gosh. Failure to warn. Only with how much money the respective creator generates. It doesn't matter. It doesn't matter. Actually, if they were discriminating based on content, that would probably be more wrong than how much money they generate. Further, defendant Patreon had actual knowledge from an outside source of information about criminal activity. There is no criminal activity. The only criminal activity was the restraining order that Jessica Irene Blum has, right? That if she contacts 80s Girl again, or 80s Girl's employer, because she's a pile of garbage, contacting other people's employers, trying to get them fired based on false allegations, if she does that again, the cops get called and she goes to jail or gets a fine. Internet tab says criminally incompetent. I'll say it. Thank you. What are you doing? Another one? I'm switching you to bourbon.
Is it good?
Oh, yeah. Sweet. You'll like it. All right.
Is that enough?
That's plenty. Trust me. Okay.
I'm back in here in 2 minutes. You're in trouble.
Oh, slow down. Okay. Further, criminal activity. No. Plaintiff Azunian contacted Patreon about defendant Herrera's use of Patreon after he had already signed up. Okay. Plaintiff Zunian was never given any type of warning by Patreon either when he signed up or after he signed up, and began to using Patreon that it could be used for such nefarious means. Why? Gosh, your sentence structure is just terrible. Matt Tobin says, "Yeah, girl, get that brown drank." And again, thanks, pal. This is the worst sentence. This is worse than his earlier sentence. Or that Patreon favored certain creators such as Defendant Herrera over other creators such as Plaintiff Azunian. Like, use semicolons and commas, not end dashes. That doesn't make any sense. Why are you using end dashes there? Based on how financially successful the respective creator was, you should just infer that from common sense business, except, again, Maddox. Like, I guess we should accommodate Maddox's autism and his inability to make a proper business decision. Further, plaintiffs were certainly not aware that creators on Patreon could use Patreon to harass, stalk, abuse, defame, threaten, post confidential or private documents, or disseminate racist, obscene, and hate-filled shows based on violating the legal rights of plaintiffs. This is all just disgusting conjecture. The Dresden 101, Rekieta Law, your wife is cutie 3.14, cutie pie. I agree. She is a cutie pie. Let's see. And encouraging their listeners to do the same and or destroy Plaintiff Azunian's Patreon through spamming and other nefarious means. How do we destroy Plaintiff Azunian's Patreon? His Patreon's been sitting at the same terrible rate for months. Patreon's terms of use expressly prohibited such conduct, and no one's done it. Chap 666, Nick's sixth kid will be conceived tonight.
Someone just said they wanted me to come on camera and tell them I'll come on for 100.
Oh, okay. Midnight Scotch Lady Rekieta says that she will show up on camera for $100. But, you know, that's up to you guys. Internet Tab, whose network has a show which had a host who used the N-word? That's a good question. That's a good question. All right, moving on. First, in the terms of use contained in Exhibit 2, Patreon expressly prohibits 18 categories that users may not use Patreon for. For instance, users may not defame, abuse, harass, stalk, threaten, or otherwise violate their legal rights, such as but not limited to rights of privacy and publicity of others. That hasn't been done. Publish, post, upload, distribute, or disseminate any profane, defamatory, infringing, obscene, or unlawful topic, name, material, or information. It hasn't been done unless you count profane words like, you know, swear words, common swear words as profanity, which Maddox would also be in violation of. So that's interesting. Use of service for any purpose, including but not limited to posting or creating content in violation of local, state, national, or international law. Wasn't done. Impersonate another person or allow any other person or entity to use your identification to post or view comments. That was done by someone on the Madcast Media Network against Madcucks. Maddox, you lying coward. Post the same note repeatedly, referred to as spamming. Spamming is strictly prohibited. Who's done this? Like, why would you even include this? You left out 4, 5, 6, and 7. Why would you include this? 10. Download any file posted by another user that a user knows or reasonably should know cannot be legally distributed through the service. When has that happened? None of this stuff has been alleged. No, Jamie Hughes, she won't take Dickles. Restrict or inhabit any other user. Corey Jamnick says, I live in Minnesota. My neighbor called me a cuck. You want a new client? Yeah, let's do it. Restrict or inhibit any other user from using and enjoying the public areas. Impossible. 14. Hack or interfere with the service, its servers, or any connected networks. Why are you including this? 15. Adapt, alter, license, sublicense, or translate the service for your own personal or commercial use. Again, that's not even alleged in your stupid complaint. And 17, upload content that is offensive and or harmful, including but not limited to content that advocates, endorses, condones, or promotes racism, bigotry, hatred, or physical harm of any kind against any individual or group of individuals. Are Armenians a protected class? I don't know. That hasn't happened, except on your network. Based on the foregoing, it would be temporally impossible for Plaintiff Azunian to be aware of the specific hazards posed by the use of Patreon's product, because such use is that Herrera was engaged in. But Even if we take your stupid, bad, garbage argument as true, even if we take it as true, it didn't happen on Patreon. Lydia Schewitz, I already sent $5. Could it be cumulative, please? I think it would be fun to hang out on the stream with Lady Rekieta. I think it would be too. I absolutely think so. It's up to her. She's watching. She's always watching. In which plaintiff orangutan reported to Patreon on 7 different occasions were expressly prohibited. Under the foregoing circumstances, Armenians are the opposite. They're an encouraged class. Oh, goodness. Under the foregoing circumstances, Patreon therefore had a duty to self-produce a warning, which it failed to do. They're just making stuff up. Other issues raised by defendant Patreon relative to proximate causation or other actions they could have taken or additional safeguards are not subject to a motion to dismiss must be reserved for the trier of fact. Footnote, here Patreon failed to provide any warning or do anything to prevent. They don't have a duty to do so. You haven't even made a prima facie case that they have a duty. Under New York law, however, the extent to which a risk may be deemed to have been obvious is simply another factor in determining the degree of reasonable care exercised by the parties, and as such must be reserved for the trier of facts. Except that, like, you're talking products liability, and this isn't a products liability case. You haven't even alleged specific damages related to product liability. Matt Tobin, Lady Rekieta, give this man another child he does not have the time for. You heard it, sweetie. There it is. There it is. Gatsgat says $2 for a hand. You're obligated now. You better get in here at some point. Once the stream catches up, we'll see how quickly she gets in the room. Plaintiff stated a cause of action for fraud. I'm just going to keep going until she shows up. As to the fraud theory, a plaintiff must prove a misrepresentation which was false and known to be false by the defendant, made for the purpose of inducing the other party to rely on it, and justifiable reliance on of the other party on the misrepresentation and injury. Here, Patreon and Cope made misrepresentations of material fact to plaintiff orangutan that were false and known to be false. Known how? Uh-oh. Here she comes.
I had to put clothes on.
She had to put clothes on. Sorry. Say hi. You can talk. There's a mic.
Hi.
It'll pick you up.
Hi, everyone. You're my buddies. You don't know me, but I watch your conversations. It's fun.
We're on page 26, the Farfus? I don't even know. So thanks, guys, for getting her on the stream finally. I've been trying to do it for a while, but you guys did it.
Anything.
No. Matt Tobin, you're the man.
Thank you, Matt Tobin. I knew someone would do it. I went and got clothes on.
So, I guess we should get through this. We're almost done. Do you want to sit down?
It's up to Matt. He's paying my wages here.
Yeah, Matt, you don't have to do another super chat, but you could just drop in the chat if you wanted to stay on stream or not. It's your dollar. You're gonna have to move over though.
I'm waiting to see what he wants.
Oh my goodness. She said sit down, or he said sit down. So scoot over here. All right, we're doing a tandem stream.
That sounds gross.
Tandem stream is not.
It's not a key thing.
Trump may have done that in Russia. We don't know. Alan Foster says, I tell Nick to drink all the time. Now I get to tell you drink. Okay. So let's see. The Trust and Safety Team at Patreon is a department responsible for handling complaints. However, Mr. Cope was not a member of the Trust and Safety Team. He doesn't have to be. Like, Hatbuckle says, you two look great together. Love you guys. You too, man. I hope to see you at another Road Rage. And you can keep me outside in the cold for longer. And I can shiver to death. But hopefully the next one will be in the summer. Patreon and Cope deliberately directed plaintiff to deal with Cope on all matters relative to his complaints and not the Trust and Safety Team. Right, because you don't get to deal with the Trust and Safety Team. You get a liaison. This was done by Patreon and Cope to fraudulently induce plaintiff's trust and complacency. Trust and safety. So that Patreon did not have to take any action against defendant Herrera, one of their most profitable creators. This was a misrepresentation of present fact. What? namely because Patreon had no intention of taking any action for plaintiff that was averse to Herrera. The fact is that neither Patreon nor Cope individually or collectively conducted any investigation or generated any reports despite representations to the contrary. Further, Cope represented the plaintiff that he had forwarded all of the information sent by Mr. Orangutan to Patreon's head of trust and safety. I'm going to get to your chat in just a second, some kind of taco. And that he would be raising it in person at our weekly meeting too. This simply did not happen. How do you know it didn't happen? Some kind of taco says virgin binge drinking lawyer versus Chad Scott sipping attorney. Yes, chap 666. Do you ever prima facie Mrs. Rekieta? Do you ever prima facie on the face of things?
I have no idea.
I think she does.
I guess I do.
I think she has a prima facie.
Oh, you see what he did there?
Patreon knowingly favored Herrera over Azunian for the simple fact that he was one of their most profitable, quote, creators. Now he's not an actual creator. He's a fake one, and generated a substantial, quote, user base. You guys aren't real users. Those are just weird quotes. Therefore, Patreon refused to do anything against Herrera. Is your wife single? If so, can I have her number? She's taken. Fight me. Therefore, Patreon refused to do anything against Herrera and did not stop his conduct, and instead extended the means by which such defendant Herrera's conduct was able to continue. You can help me if you see something funny.
I sit and read them all. I think they're hilarious.
For financial gain while simultaneously representing to plaintiff. Why do you have a comma after simultaneously? How bad at English are you? Representing to plaintiff that his complaints were being, quote, addressed. Yeah, so they told you your complaints were being addressed. You just didn't like the resolution. That's different. Do all your kids have ice blue eyes like that? Yeah, pretty much. They do.
If they ever don't, I'm worrying about who the mother is.
Yeah, they have a cool combination of both of our eyes, actually. Anyway, this is a misrepresentation of present fact as well, given that Cope was not even a member of the trust and safety team, because he couldn't go tell them. Right? It's impossible. It's unforeseeable that someone working at Patreon would be able to contact another member of Patreon. Gatsgat says the stream just got demonstrably better. I think it got much better looking.
Someone said to stop yelling because we're gonna wake the kids. The kids are at a babysitter tonight.
Yeah, the kids are gone tonight, so
except for the baby.
It's all us. Baby's here. The older kids are with grandparents. So. Yeah. Had no authority to take any action against Herrera nor perform any investigation into plaintiff's complaints. Complaints are good. They're made with eggs. Therefore, the threats and harassment against plaintiffs continued for months on end, while Plaintiff Azunian continued to correspond with Cope. Number 6 is on the way tonight. And provide him...
I'm reading.
Sorry. It's distracting.
I know.
And provide him a substantial amount of evidence against Herrera, of Herrera's conduct thereto. Your wife says my name, everyone has to give you $1. I know they'll do it. Trust the system.
Clay.
Did that go through?
I don't know.
Lady Rekieta should be your Szechuan. Yes, I agree. You could be my audio engineer with witty zingers. Yeah. Therefore, Patreon and Cope made multiple material misrepresentations or omissions of fact to plaintiff Orangutan relative to Patreon's practices and procedures and investigations of complaints. Patreon and Cope had knowledge of the falsity of said facts. Mr. Cope misrepresented or omitted said facts with a fraudulent intent to induce reliance. Reliance on what? What action did Maddox actually take relying on Cope's misrepresentation? Someone tell me. Four more pages. 4 more pages. Yes, moderator. Thanks for.
Tessa's gonna hate having me on the show.
Clay just got a ringtone. That's funny.
What's ASMR?
It's a type of. It's like doing a video like this. Okay. Very soothing. Auditory. I don't remember what the acronym is. Thanks, Joel Schwabe. Schwabe. All right. So, yeah. Plaintiff orangutan justifiably relied on Mr. Cope's misrepresentations or omissions to his detriment and suffered substantial injuries and damages thereto. They haven't even alleged what the injuries and damages are based on Cope's misrepresentations, so that's just stupid. Citing Mulberry, university researchers' alleged awareness that his letters to restaurants were used for purpose of eliciting a response from recipients, namely restaurateurs' responses to complaints regarding food poisoning from putative customers, in combination with restaurateurs' reliance on information communicated in letters to rectify a non-existent problem. And researchers... guys, I'm going to be honest. I've been drinking a little bit, and I don't even remember the beginning of this sentence. She's got a purty mouth. I agree.
It's real creepy. Thank you.
Reliance on information communicated in letters to rectify a non-existent problem.
I'm going to read James's quick.
I had no idea you had your office set up in your kitchen. Oh, my goodness. Where was I?
Sorry.
Seriously distracting.
I know.
You know the kind of quotes or like the comments I'm going to get following this of, this sounded really stupid when I wasn't on it live. Well, watch it live, guys. Watch it live. And your comment proven immediately. Okay. Supported restaurateurs' fraudulent, negligent misrepresentation claims against university and researcher. Whatever, who cares? Plaintiffs have stated a cause of action for promissory estoppel, which is like the funniest thing I can think of. This is such a hard claim to show. In New York, promissory estoppel has three elements: a clear and unambiguous promise, reasonable and foreseeable reliance by the party to whom the promise is made, and an injury sustained by the party asserting the estoppel by reason of the reliance. The concept of promissory estoppel provides a remedy for persons who detrimentally rely on the promises of others and are injured thereby. Thus, in order to prevail in the instant action, plaintiffs must demonstrate that defendant what? You left off the most important part of the quote. Edit. Hire a paralegal. Do anything. Drink more, coward. I don't know. I don't have any more cowards to drink. Let's see. I do have a little bit more here. Okay.
We're going to run out of whiskey.
Well, I still have a whole bottle right there. I just haven't opened it yet.
Yeah, I know, but these other ones are almost gone.
Yeah. Are you going to have any more? Or are you good? A little tiny bit?
Yeah.
Okay. All right. Sorry for the delay, guys. This is important stuff.
Important.
Here, plaintiffs have clearly shown that they detrimentally relied on the promises of Patreon and Cope and were injured thereby. No, you haven't even alleged that you were injured by that. Oh, my goodness. What is wrong with you people? As set forth more fully above, Mr. Cope and Patreon promised to investigate plaintiffs' complaints and do something relative to Herrera's conduct. Patreon and or Mr. Cope, as a reasonable person, could foresee that his promises would induce plaintiffs' conduct of the kind which occurred in this case. Which conduct? They didn't do anything. What conduct occurred in this case that caused an injury? Plaintiff's apostrophe. Even drunk, I can tell that his grammar is bad. Therefore, actually relied on Mr. Cope's promise to do something which resulted in a substantial change in plaintiff's apostrophe position. Oh, that's the right one. As it placated plaintiff's apostrophe for months on end without any resolution, and to the present day, nothing has been done by Patreon. So plaintiffs were forced to advance a civil action against the company and Mr. Cope personally. Your legal claims are unrelated to Patreon's duty to do anything for you. Uh-oh. You're going to have to sing this one.
What?
There's one coming through. It just, for some reason, it comes through on here before it comes through on my screen, which is crazy.
What do you mean I'm going to have to sing this one?
It's an Elton John song. Plaintiffs clearly have claims under general business law. Where did it go? My chat stopped.
It's on top chat now.
Oh, why is it on top chat?
I don't know. I just noticed.
Terrible. There it is. Sorry. Can you feel the love tonight? Anyway, that's all I got. That's all you quoted. That's all you get. Sorry.
I'm glad you did it. I was like, oh Lord.
You should have done it. Sound better.
I
Allegations that the acts complained... Okay, so this is plaintiffs clearly of claims under GBL 349-350. Allegations that the acts complained of potentially affect similarly situated consumers are sufficient to show that deceptive acts have ramifications for the public at large. Like, why is he making legal arguments here? Are we going to get an erotic story for real men tonight? Oh, no. And we need a singing stream. That'd be a disaster. Only if it's like one line at a time, guys.
You gotta come join us for some SingStar, though. We haven't done that in a while.
Yeah, come to Minnesota and karaoke with us. A deceptive practice or false advertisement will likely be consumer-oriented if it is standard practice of a given individual or company. ExxonMobil, you have to sing it again, showing the shirt. Oh. She has to sing it this time.
Can you feel the love tonight? That's all I got. I need more liquor for more.
Here is set forth more fully above defendants' Patreon and COPE's representations or practices were deceptive and likely to mislead customers acting reasonably. Defendants apostrophe Patreon and COPE engaged in deceptive practices or acts with knowledge of the deception and directly participated in a deceptive scheme against plaintiffs, namely to favor one creator, Herrera, over another creator, Uzunian, on their platform. Guys, I have the best idea. She's not looking. She's not looking. I'm not looking. We have to ask Dick to bring me and Miss Rackets to LA for a Twitch stream, for a Friday night music Twitch stream with Dick. Got a huge office in Minnesota. Here I come. And Jamie says, for the record, I actually did hear Asterios cry one time. He didn't know he was on speaker. Aw.
Poor guy.
This is, again, Asterios is a good dude, and he does not deserve any of this. Patreon.com/Asterios. More importantly, patreon.com/Lawsplaining. Let's be real here. We're still capitalists in this house. Okay. Let's see. Defendants Patreon and COPE, defendants apostrophe, Patreon and COPE engaged in deceptive practices or acts with knowledge of the deception, directly participated in a deceptive scheme against plaintiffs, namely to favor one creator, Herrera, over another, Uzunian, on their platform. That's not a deceptive scheme. That's just what businesses do. Chap666, Dick, you have to pay Miss Nick to read erotic stories. That would be great. No. Patreon generates its revenue based on a 5% commission, only classy erotic stories, guys, from its creators.
There's such a thing.
Out of 1 million users, we have 5 children. Of course there are classy erotic stories. Out of 1 million users, less than 50 generate over $150,000 a year. Defendant Herrera is one of them. Therefore, Patreon's standard practice is to favor its most profitable creators who generate the most revenue and user base above the other creators, such as Orangutan, who generate significantly less revenue and user base. Just say that it's sad and pathetic. This practice affects every user or creator on Patreon's platform. Clay Early says, here's my dollars for the wifey call out. Everyone call Tess mommy. She loves it. And Hatbuckle says, can we have Mrs. Rekieta say, picking up a pound of blue cheese from the Perkins, then headed to the Mall of America and other Midwestern-y accented stuff. You've got to say it. There you go.
Okay. So I have to sound Minnesotan? Is
Just-
that
just-
what the mid
Trust me,
Western-
you'll be fine. You'll do it competently.
Picking up a pound of blue cheese from the Perkins and then heading to the Mall of America.
A? That's Canadian.
That was Canadian.
We're diet Canadians. We use
Diet.
A every now and then.
A.
Rip Tyler Jones.
I never know what I'm saying.
This is more than sufficient to state a claim under GBL 349 and 350. That's presumptuous. Guys, if you haven't figured it out, he is just a terrible, terrible lawyer. Please, this is a Christian stream. And we are a married couple.
Oh, no, I'm not wearing a cross. Never mind. I thought I was wearing a cross. I'm wearing keep going.
Evidence
it
that
doesn't show up.
automobile insurance company had practice of dissuading or preventing consumers from using auto body shop, and that this practice had broad impact on consumers at large, i.e. any of companies' insureds who brought damaged car to shop for repairs satisfied consumer-oriented element of shop's claim against company. No, like, I can't even explain why this is so dumb. The consumer-oriented provision means that this is a right reserved for consumers. The more Midwestern you sound, the harder I get. Oh, buddy. Me too.
You guys are making me very uncomfortable.
The consumer oriented.
Wait, I gotta throw out to this guy. Go back up.
Who?
What do you say here?
Hat
He's
buckles?
fleeing the interview. Does that help you? He's fleeing the interview.
Oh, okay.
I don't know. I
don't know.
I was helping out.
I don't know. I don't know how Landau is missing this. Consumer oriented.
What cleavage? Sorry.
Consumer oriented under general business law means that the right to sue and the right for damages is reserved for a consumer of the product. That's not alleged here. Sorry, nothing. Don't worry about it. Falsely advertising customer services and disseminating fictitious testimonials over the internet, such as disguised source of email messages to group members. Why did you emphasize this? That hasn't even been claimed. Was sufficient as basis for false advertising charges. All right. While consumer
Internet tab knows me.
Magical K reminds me of Wife with a Purpose sans the creepy vibe. I guess sans the creepy vibe. We're not at 4 more pages. We're at one short page after, just a signature after this. We're almost done, guys. While consumer protection statute does not require businesses to ascertain consumers' individual needs and guarantee that each consumer has all relevant information specific to its situation, business may have liability when it possesses material information that is relevant to consumer and fails to provide that information. Conclusion, release requested. For the foregoing reasons, I'm a dumb idiot. Please dismiss my case. That's what it says. Just trust me. I will not read the rest of his words. They're far too stupid. It's done. It's over. Respectfully submitted, the Landau Group PC. Kevin Landau, attorney for plaintiff's apostrophe, the most embarrassing attorney I can possibly imagine. Get a paralegal if you don't want to do it. Gatsgat says, don't you know if someone made you feel uncomfortable, you can sue us all for $20 million each. She's not 100% caught up on these. She's almost caught up, but she does know that at this point. I need more scotch before the snowstorm hits tomorrow. That's true. I do.
Are we really getting snow tomorrow?
We're supposed to get snow. Yeah, at some point. Who knows?
I thought we just got snow.
We did just get snow. All right, guys. Thank you so much for joining us.
Notice how quickly he went through it all once I got on stream, huh?
Yeah, well, I got to get her off the camera. It's dangerous. Every moment that she's on is a liability to me.
It's true.
Poor moderator.
Sorry, Tess. I love you.
Doxed. She doxed her.
What? Her name does not come up. Or her name not come up?
It's right
there. It says Tess.
I know.
How am I doxing?
I just call her moderator.
It's right there.
Well,
I think they can all
yeah,
see it.
and Jessica Blum's name and Maddox's name are right there too, but that's doxing. Getting like 10 inches in Duluth. Some people would say that's a good thing.
Snowstorms are keto.
Snowstorms are keto.
I'm with you.
Thank you guys so much. I'm going to wrap this up. I'm going to let the stream run down for just a little bit. If you have any last minute questions about this, let me know. And let me answer one question straight out of the gates. This is a terrible, terrible document. It's garbage, bad arguments, bad citations, bad understanding of law. At this point, though, is that really a surprise? Andy Polo off the camera and into the bedroom.
I love you, Andrew. I saw your messages.
I'm not going to read it on, but that's funny. Good job, Puma Pants.
Puma Pants.
This is a Christian stream. This is a Christian stream. What is snow? I live in Arizona. Never seen it. Thank your lucky stars, buddy. Bad signature too, to be honest. I agree, Clay. Do more lawsuits begin with motion? Most lawsuits begin with motions to dismiss. Yes. That's in all honesty, like a motion to dismiss is the most common first response to any lawsuit. Like it really is, because if you can win right away, you just win. Why are there so many of these documents? Is there back and forth with these, or is it just piling on? No, all of this back and forth will end soon. Actually, Asteriosis should be coming to an end in early March, so we should get our first rulings fairly soon. It's 30 days from the last documents. Law 44 UK, yes, unfortunately you missed it, but you should be able to rewind and go back to the beginning. To a road rage down under. If I could get to a road rage in Australia, that would be great.
I would go to Australia.
Chap 666 says Lady Nick is getting 10 inches tonight. which is a lot of snow, and I will have to shovel it.
I'll put him to work.
How much fun do you think Patreon's going to have ripping this piece of garbage document apart? I hope they have fun with it. Their first motion, or their first motion wasn't very flary or creative. It was very matter of fact. I hope they realize that this is just garbage and tear it up. Is Mrs. Rekieta also an attorney? No, Mrs. Rekieta is a respected educator. She is our homeschooler. She takes care of the children while I go drink scotch in my office. Anarchist Bunny says, if LANDAU DUI gets disbarred in New York, will the Michigan bar evaluate his behavior? Do they only care about lawyer actions within their own state? I mean, they may care about his actions in New York. It really depends on what the New York bar would determine and if Michigan would take it. How much did my stomach hurt after your drinking game? Clay, you should probably be dead. Get to a hospital. How do I get a hot wife? Did you use a net? Yeah.
Yes.
Pretty much.
He had to. Can I?
I don't care what you say about me.
I made him become a cheerleader.
I was a cheerleader in college, y'all.
Cheerleader.
Be a cheerleader in college.
Be a cheerleader.
Internet Tab says, buy a snowblower, a Toro. It will change your life. Honestly, Internet Tab, let me tell you a story. I have a 500-foot long driveway, and we did have a snowblower, which was a Toro, and it's broken twice. Hatbuckle says, in all seriousness, thank you for doing this, Mrs. Rekieta. Thank you for letting him do this for us, and much love to both you and your gigantic GD family. Thanks, buddy.
You're welcome.
I'll see you on the IRC. All right, guys. I'm gonna go to blank, and I'll answer a couple more questions. But once it blacks out, we're gonna wind up the actual video and the talking. So thank you all for joining me. Tons of fun doing these. Monday, Dick's response is due. I expect it to be hilarious, and we'll be covering Dick on Monday. Yeah.
Where'd it go? It jumped up.
Which one?
Somewhere.
Do I like Ayn Rand?
No. It jumped. It went so fast. I don't even know.
Is it the one where...
There it is.
Yeah. So, no, not at... Well, in Minnesota, yes. At Southwest Minnesota State University in Marshall. That's where we went. Is this the part of the stream where it switches from YouTube to Chatterbait? How many tokens? Oh, my goodness. All right, guys. I'm going to blank it out. And once it goes blank on YouTube, I'm going to end the stream. And I'll answer a couple more things in the chat. Thanks for joining us. Lots of fun. Really appreciate it. You guys have a good night.